As there are some fans running and no PA system, can everybody please remember to try and project their voices so that they can be heard throughout the proceedings? Thank you. Can everybody please switch mobile phones to silent and also turn on email notifications on laptops so that we have as clean instructions as possible, please? Can I please ask one of the council's officers to explain any fire drill or fire alarm procedures, please?
Yes, hopefully, if you haven't done already, but at some point, if you can sign the signing in sheets that are, I know you've done your reception as well, but sign the ones in that are on the table out there. In the event of a fire alarm, we go out of the door, fire door just over inside this hallway, and we make our way around to the back of the building into the Abbey Gardens. And then I will take the signing sheets with me and do a roll call. There's a fire alarm test at 11:30. 11:30 today. 11:30 today. So
noted. Thank you very much. Okay, and on the point about the weather and the temperature, please feel free to remove jackets and or any formal attire. Make yourself responsible, but please know that this will still run as a formal event. Okay, thank you. So in terms of who I am, my name is Holly Nichols, and I am the inspector appointed by the Secretary of State to conduct this inquiry and to determine this report. And that is an appeal made by Nicholas King Homes Limited against the refusal of permission by Vale of Whitehorse District Council for an outline scheme of up to 249 dwellings, including means of access on Stone Hill, and all other matters reserved. That's a site again at north of Stone Hill, south of the accused with south. So please can I ask for introductions from those that will be appearing before me today, starting with Olivia Post.
Yes, good morning, Mum. My name is Sasha White. I am of King's Counsel, and I'm going to call the following witnesses, and their details are set out in the opening, so you don't need to write too much about taking notes. But firstly, I'm going to call Mr. Alan Duval, who's sitting to my immediate right. He will give the planning evidence probably tomorrow. I also intend to call Mr. David Neame, who is sitting two down from Mr. Duval. He will give the housing land supply evidence, the appellants in the round table this afternoon. And then behind Mr. Neame is Mr. Tucker, who's put in a proof of evidence, but we will discuss whether that's written evidence or whether he is required to give evidence on the light of you or any other parties' position. And then lastly, there's also an affordable housing statement by Miss Annie Gingle, who is not here, but that is intended to prove Mr. Duval.
Thank
you.
And the council students.
Good morning. My name is Emily Lambert, counsel instructed by Vivian Williams, Deputy Head of Legal. In the same way, the appearance is set out in my opening, so not to worry about detailed notes. I will be calling to my left Helen Reid on housing land supply, and to her left Mary Jane Engel.
Thank you very much. Okay then, and can I please have a show of hands of any interested parties here who wish to speak today? From online? Oh. Go online, okay. Can you please introduce yourselves?
no, they can't, because we didn't have anyone registered to speak. We expressly asked, so we've not got. They are.
I registered to speak and I had it confirmed. Graham Thompson from local residents.
Brilliant, thank you. That's as much as I know then. Are you all connected by Teams?
I'm on Teams, yes.
You're on Teams. Mr. Barnett?
I think Bob Barnett, do you want to speak as well?
I'm just here to listen for the moment, thank you.
Okay, thanks.
And that's Councillor Rayner. Are you by Teams as well? Yes.
Yes, I would like to speak as resident and councillor, and would like to speak, if possible, after I've heard the council's opening statement.
Sorry, Mum, yes, sorry, it's the heat. In my defence, I'm going to stick with the heat.
Thank you. Stay with us. We will hear from you after the opening. That's okay. Bear with me.
Thank you. I'm so sorry. I really can't hear very well. I'm trying my hardest.
Okay, then on that point, I trust that no one else is intending to record the event in any way, but we are being live streamed, so please take note of that. This inquiry is being opened following a case management conference, which was held between the main parties to discuss the case management and not the merits of the case. In addition to the case management conference, we have exchanged emails on the main issues and the way of dealing with the evidence and programme. So we have a clear view now on how the inquiry should run. The council has provided you with notification letters that had been sent, and they were in connection with the original application, with the appeal itself, and then also in relation to the arrangements for this inquiry, all of which appear to be in order, unless anyone has any views to the inquiry. And the council has already as well provided me with copies of representations that were made in connection with the appeal application. And I have received those that were submitted in connection with the appeal, which I will take into consideration in reaching my decision. I have received the core documents and the proofs of evidence from both parties, all of which I have read, so they can be taken as read. All of that material is on the council's website. The procedure and timetable, in terms of the conduct of the inquiry, it will run under the procedure set out in the inquiry procedural rules from the year 2000. For those that are unfamiliar with these processes, it will involve this inquiry in particular running for up to about 4 days, which will include today and the remaining working days this week. And if anyone should need one, there is a copy of a printed timetable available. When I've concluded my opening remarks, we will hear an opening statement from both main parties. This will help everyone to understand the main arguments. We will then hear from the interested parties online who wish to speak. And for those that do intend to speak, I may have some questions for you, and it is customary to allow the appellant's advocate to ask questions if they have any. And later today, we will have a roundtable discussion on one of the main issues in dispute, which is whether the council can demonstrate an adequate housing land supply. And we have a specific agenda available for that discussion. The final item for today will be off-site, and that will be an accompanied site visit, the arrangements for which we will make in due course. I already understand where the site lies in context of its surrounding area, so I have some familiarity with the area. We'll get to the arrangements for that in due course, but as has been highlighted, it is a particularly hot day, so please take note that it will be a rather sort of informally dressed occasion. Tomorrow, we do intend to start with the formal exchange of evidence, and as Mr. White outlined, it will be at least both planning witnesses for parties and question mark on whether there would be a need for the sustainability witness for the appellant to put their evidence forward, given that they may not be being cross-examined now. And our business on Friday will involve discussing the planning obligation and the planning conditions on a without prejudice basis, as is customary as part of hearings and inquiry procedures. On Tuesday next week, we will be resuming online to hear the closing statements from the main party. On some other procedural matters, I haven't had any cross applications foreshadowed at this point, and so if either party intends to submit a cross application, we would need to do so for the close of the inquiry. And as you'll be aware, I also have the power to initiate and board costs if I see it fit. So the documents that I have explained have already been submitted to me are all available on the council's website. In terms of the more recently submitted documents, the email I received this morning contained the final draft planning obligation, which I will record as inquiry document 1, and which I will make some opportunity to review in due course. I don't believe I have received a final draft list of planning conditions or a regulation 122 statement from the council, separate of that submitted by Oxfordshire. So can I flag that and ask for some discussion to be held about when those items will be submitted?
Yes, and that's an instruction.
Can I raise, but I've talked to my team about that, and it also, and I plan to see, I think that in relation to conditions, I know the council provided their set of conditions, we've gone back with our comments. I think it's fair to say probably a discussion is necessary. I was going to suggest that as Friday is just, as you say, we've agreed on the 106. So apart from your questions and the issues, I don't think my learned friend and I will be having a debate around its content because I'm told it's agreed. So I was going to suggest that potentially if you would consider we don't sit on Friday to say just having an hour. I don't believe there are other applications on Tuesday that we've identified. So Tuesday we can spend an hour on the conditions 106 first thing, then do closing. And that would enable Friday morning for those that represent the appellant and those that represent the council in relation to conditions to have that session and send you by lunchtime, hopefully those that are agreement and those that are still in dispute, you have time to consider it over the weekend. That also, frankly, saves your time. I just don't personally think it's a particularly good use of inquiry time for us all to come in for an hour on Friday. But that's my suggestion. But of course, it's at your discretion. If you prefer to have the session on Friday, so be it. And that's what will happen. But just to give you the context, that's where we are with the conditions. And I don't know, once I learn the taking instructions, but my understanding is that the LPA are considering our comments on their version of the conditions. So the good news is the process has commenced and started. I mean, it does need another stage before anything is presented to you, unfortunately. Unless you would like to see where the debate sits now.
Okay, so I hear what you're saying. As I said, I haven't had an opportunity to review the final draft section 106, but I've obviously seen earlier versions of the same. So, I don't know what my questions might be at this stage. I'm open to that suggestion, but can we confirm that first thing tomorrow? I think that would be my preference, because I'll have had the opportunity to review this section 106 in more detail by then. If that is the suggestion that we go with, then my preference would also be for that final list of conditions and council's accompanying SOREC statement to come in by that Friday lunchtime and then back. All right, so point of that was to say I haven't received those items. I have received all the other items I was expecting. This is a reluctant invitation for people to submit anything further. I'm not inviting anything, but just in case anyone intended to submit me anything, I'd like to understand what that is now. So to frame context of this inquiry, I'll just reiterate the main issues that we identified through the decision notice and case management conference process. And the main issues are the acceptability or otherwise of the site proposed development having regard to the development plan and to national planning policy. Whether the council is able to demonstrate an adequate supply of housing land in context of requirements under national planning policy, and whether the planning balance weighs in favour of the granted planning permission or against, including whether the plan falls to be assessed on a tilted or flat basis. The most recent version of the statement of common ground agreed between the parties identifies some other considerations and nuances around where weight is to be attributed and not, and these will obviously factor into my decision. And those other points will no doubt become apparent through the opening of the evidence from the parties. Before we get going proper, does anyone have any comments on the nation? So those are my opening remarks. Does anyone have any questions about the procedural side of the inquiry or the approach?
Yes, I slightly long one. Would it not help if that's right? Quite dark.
Let there be light.
I don't think light affects people, but I did do well in my physics.
Maybe by 0.2 of a degree.
Might also help those online not thinking they're looking into the gloom. Isn't that better?
Yes, we're all very visible now. You do. Questions? Anyway, so those are my opening remarks. Let's commence then. So, opening statements, please.
Well, following what I said earlier, as you can see, on the housekeeping is the list of appearances, and just to deal with the geography of the opening, it's got two appendices. At page 17 is the chronology in this matter, which I hope is not too contentious, and I've set out the references in the core document where you will find things. And then on appendix 2, which I always think is helpful for you, is the policies. And again, I hope this isn't contentious, because what it does is it sets out from the statement of common ground the policies that are relevant for your consideration. And in black, I've identified those that are still contended under reason of refusal 1 to be breached. And I actually think the same, both in relation to the first page on page 19 is part 1, part 2 is on page 20, and you'll see that effectively, I think there's pretty much agreement between the parties, as you can see, on reason of refusal, out of date weight. Those are Mr. Duval's views, not Miss O'Neill's, and the appellant's position on conflict. I think those are likely, and as I've said, that should just help you when you listen to the evidence tomorrow and what policies are in play, frankly. So I don't think, unless you want me to, I'll go through that, but it's just to assist you. And the chronology, as I say, shouldn't be too contentious. It principally deals with the application, also sets out the development plan and phrased in terms of that is adopted. You can see the first item is the adoption almost 10 years ago of the part 1. And then there's also the review process and the dates that affected that. And then the application itself. And one thing to note, and I'm sure you've seen this from CD A and B, there were various revisions to the proposal that were considered by the LPA. The application was refused on the 20th of October 25 for 8 reasons of refusal. I've set those out. And then we've also got what obviously forms the basis, the HLS in December. The appeal submitted 3rd of March. You'll recall the CMCU held on the 5th of May, exchange on the 27th. Then we had effectively the planning statement on the ground signed, etc., etc. So I will also take documentation. I'll also take the statement. So could I start at paragraph 4? And this is the core case for the appellant in this appeal, Mark. We say that the case is compelling. You're dealing with a site which is free of all technical constraints, which is located adjacent to a settlement well served by facilities of public transport, which will deliver very substantial public benefits, including 249 much needed new homes and 88 affordable homes. The single substantive issue dispute is the conflict alleged by the council with the use of one with spatial strategy, which is now approaching 10 years and which has demonstrably failed to deliver an adequate supply of housing during its life. We say, indeed, you could not get a better greenfield site for housing development. As you've heard, there were 8 reasons of refusal last October. We now have the agreed position that either 7 have either fallen away entirely, which is effectively 2 to 5, and a further 3 are addressed through the agreed section 106, which is 6 to 8. Sole remaining issue, therefore, is reason of refusal 1. We say that when you consider reason of refusal 1, the following is important. The first is, of course, Mark, that there's a national housing crisis, which has been described by government ministers as the most acute housing crisis in living memory. Nationally, we need to provide approximately 375,000 homes per annum in order to meet this government's milestone of delivering 1.5 million new homes in this farm. Of course, that target is not academic, but reflects very real situations faced by very real people who are in desperate need of improving housing or new housing. In essence, all hands need to be on the tiller to achieve that requirement. We also say when you look locally, as you'll hear from Mr. Neame this afternoon, the appellant's evidence demonstrates the council cannot show a 5-year supply. The requirement is agreed. You'll be pleased you don't have to wrestle with that. It's agreed at 4,982, which effectively equates to 949 dwellings per annum, plus a 5% buffer. Mr. Neame will tell you now, as a result of the addendum stated on the ground on housing land supply, the supply is effectively at 4,223 dwellings, which mathematically divided 9, the requirement by the supply gives you 4.24 years, which represents effectively a shortfall in quantum of 759 homes. Even the council's case, as you'll hear from Ms. Reid this afternoon, demonstrates a supply of only 5.34 years, barely above the threshold, and we will demonstrate based on unrealistic assumptions about deliverability across particularly the category B disputed sites and actually windfall as well. We also say there's no realistic prospect of the shortfall being remedied. The development plan is 10 years, and as you will hear, the emerging joint local plan has been submitted for examination, but has been caught up in various debates, and hearing sessions are now scheduled for July. Whether I'll be in this room or elsewhere, but July and further potentially in autumn. It is agreed between the parties that very limited weight can be afforded to it. The draft neighbourhood plan is at an even earlier stage, Regulation 14, and agreed carries limited weight. Therefore, there is no adopted plan on the immediate horizon which will address the current housing shortfall, and the only solution is short-term grant of permissions. Then there is only way of meeting that shortfall is by using greenfield sites. The use of greenfield sites is always promoted, particularly amongst local residents. However, there is no realistic prospect of the Vale of White Horse meeting its housing needs without the use of greenfield land. When such sites are used, they should be in sustainable locations, free of protective designations and well related to existing settlements. That is precisely the description of this appeal site. So we say this appeal will make a substantial contribution to housing needs, delivering up to the 249 homes and 88 affordable homes. The housing provision that relates to the affordable component at 35% is policy compliant, and will make a material contribution towards a very significant affordable housing need in the district. Whereas you'll see in Ms Gingall's report, the waiting time for social housing extends up to 11 years for three-bedroom property, and there are 17 households in temporary accommodation. 73%, unfortunately, have dependent children. There will also be other important benefits, economic benefits which involve the construction and occupation, biodiversity net gain, 18.45 habitat units and 184% hetero units, high quality open space and play provision and active travel and highway improvements. Those benefits will be delivered in a sustainable location. As you've read in Mr. Tucker's evidence, we say that this is a settlement hierarchy identified as a larger village. There's a range of existing services, including the primary school, several shops, a public house, and a very good bus service, the S6, which runs 20-minute frequency to Oxford, which can be accessed directly outside the appeal site. Therefore, the judgment of Mr. Tucker that the site is well connected and appropriate for residential development is correct. You also, Ma'am, as you've identified in your main issues, in the rare position that this is a large housing scheme without any objections from statutory consultees. The Transport Statement of Common Ground confirms that Oxfordshire County Council's Highway Authority is now satisfied on all highway matters. The Ecology Statement of Common Ground confirms reason of refusal 5 relating to the Barbara Stell bats has fallen away. There are no outstanding objections in respect of heritage, flood risk, ecology, landscape and amenity. The site is also not subject to any national or local landscape designation, not within the green belt, not within the conservation area, or the setting of any listed building. The council's own landscape officer raised no objection to the proposal, and there is no landscape usual, which is noteworthy and very rare in the context of a greenfield site. The LBIA, which you'll find in your A series of core documents, includes the adverse landscape and visual effect would not exceed moderate significance, and the site is visually well contained by existing boundary hedges and vegetation, as you'll see this afternoon. We say the spatial strategy conflict, such as it is, merits limited weight, and we say it should only get limited weight because any conflict should be considered in the context of the age of the development plan, the absence of a 5-year housing land supply, and the fact that the most important policies that determine the application are out of date. Therefore, you will hear from the appellant's team that there's ample compelling evidence which strongly supports the grant permission. Then I deal with the factual background, which frankly I will take as read, say that it's just important in the context of the major issue just to deal with paragraph 15, which is that this is a settlement which has been decided not by us but by the LPA to be subject to significant planned growth. You will have noted that in the local plan policy document, there was an allocation of 280 units. In part 2, the allocation of 660 units. Even my maths can get up to over 900 units effectively have been allocated by this council in the past 10 years. There's a reserve matters application currently pending consideration for the 605 dwellings under 660 allocation. This demonstrates the settlement has been considered suitable for major development and expansion by the council itself. Then the council's decision, I'll take all of that as read because it's factual. Say, could I then please move on? I do want to deal with 22 with the 5-year supply, and I've dealt with the figures. As you'll hear, Mr. Neen says 4.24, Ms. Reid says 5.34. The difference is principally on the category B. We will show that the council's assessment deliverability related to those sites is over optimistic, and you will take the opportunity to test those matters this afternoon. However, it is common ground, and this is important, that if you conclude there is not a 5-year supply, then footnote 8 requires that policies which are most important to be treated out of date. Also agreed if we do conclude that para 11D is engaged, and that would require you reaching your decision to grant permission unless the adverse impacts of doing so would significantly demonstrably outweigh the benefits from assessing the policies of the framework taken as a whole. Of course, we all call that potential balance. and we say it provides a strong presumption in favour of the grant of permission. Also agreed between the parties that there are no footnote 7 policies, which if you're in that scenario provide a clear reason for refuse of the development. Again, it means that there are no strong reasons which affect the designated area of assets which can disapply it. Then can I take the planning application as read, and I'm also going to take section 4 as read, but I just thought it was important, and this is all quoted directly from the Statement of Common Ground. There are 24 matters agreed between us and the council, all of which show in our submission the suitability of the site for development. So as you've identified, you have 3 main issues to deal with. And could I jump to para 40 and deal with the benefit? The first is the 249 new homes, which the LPA and the Statement of Common Ground accept to be a benefit. There's an urgent need to build more homes for the reasons I've set out, and indeed, national guidance requires in para 61 to significantly boost the supply of housing. The housing which would be delivered by this proposal would make a material contribution for addressing the supply shortfall in the district. The appellant, Nicholas King New Homes, is an experienced house builder with a strong track record of delivering homes across the region. And given the advanced stage, you will note, Mum, that this is not a land promoter's application, but a house builder's application. Is it the intention of Nicholas King New Homes to build out this development if you decided to get planning permission? And therefore, there has been a degree of effectively looking at the design work, and there's also been pre-commencement information that's been prepared. The appellant is confident first completion can be achieved within approximately 2 to 3 years of any grant of outline permission. We say, as you'll hear from Mr. Duval, that there should be substantial weight given to market housing. Then affordable housing, again, the LPA accept this there is a benefit. Also noteworthy in the evidence of Ms. O'Neill that there is a need in the district. So those 2 matters are settled. 35% said the relevant policy is CP24. Ms. Gingle's written evidence demonstrates an identified need of over 2,600 households unable to rent or buy, which equates to 133 households per annum. There was a shortfall in delivery of 585 homes in the past 5 years. Waiting times, as I've identified previously, are 11 years for a 3-bedroom and can be up to 9 years for a 1-bedroom property. As I've said previously, there are also 70 households in temporary accommodation, of which 73% are dependent children. And of course, Mum, these aren't mere statistics, but actually they represent real people in the real world. And the delivery of 88 affordable homes would make a very material contribution to addressing that need. Ms. Gingle's evidence, as I'm sure you thought when you read it, paints a sobering picture that there are 132 children living in temporary accommodation in the district. And as I've said, the waiting times can be extraordinary. They represent families who are unable to secure stable, suitable housing. And of course, each home delivered represents a family house and the children provided with a degree of stability and pressure relieved off the housing register. The 10-year mix is also policy compliant and will provide social rent, affordable rent and shared ownership for first homes, ensuring the needs of households across the income spectrum are addressed. Also policy compliant affordable housing offering in a substantial way. Also, when you take the overall 249 and their range of house types and sizes, there's delivery of a mix which should be given moderate weight. We also say from Mr. Duval that because we're in a sustainable location for the facilities you will have seen, the site is well related to the settlement and it has good access to local services and sustainable transport options, and again, substantial weight. One also can't forget that in the large Eastern Bagleys allocation, the 605 or the 660 is allocated, it is proposed that there be a local centre at the primary school. There are economic benefits, which again the LPA accept, disputes to weight. And of course, you know, NPPF Para 85 talks about significant weight. The proposal will generate economic benefit, and again, Mr. Duval gives that substantial weight. There will be BNG, again, accepted by the LPA to be a benefit. I've read out figures I went through, so again, this represents a very substantial environmental enhancement and again, significant weight to that benefit. There's also benefit 7, open space and provision accepted by the LPA to be a benefit, including a NEAT, a LEAP and a LAP, and that will serve both the new development and the existing community, which is about the same moderate weight. Lastly, the active travel and highway improvements you can see from Mr. Tucker's evidence with improvements to the cycling and walking infrastructure in the locality, enhancing connectivity and promoting the use of sustainable transport modes. Again, moderate weight to that. So cumulatively, those 8 benefits we say that they should be given significant, substantial weight delivered in a sustainable location which is free from technical constraint. And there's just one point which Mr. Deval identified, which is absolutely right. Also, Ma'am, I don't know if you've come across this with other caseload, but there is a question mark over affordable housing and registered providers. I'm told and instructed that there is an offer from a registered provider to take on the affordable housing, obviously assist on delivery. So there are 4 alleged impacts, I think, to weigh in the planning balance. The first, which seems the principal concern of the council, is harm to spatial strategy. And there are effectively those 5 policies are the one we need to grapple with, and it's easy to remember the CS3-1, CP4-2, CP4A3, CP8-4 and CP8A-5. Our position is that any conflict is limited because, of course, you will note, firstly, is that the level of conflict with the actual wording is small. The development plan has a degree of flexibility. CP4 allows development of larger villages in certain circumstances. We say the policy does not impose an absolute prohibition, rather it requires development should help to sustain the settlement and be consistent with its role. We say the provision of 249 homes here is entirely consistent with those objectives. Secondly, the settlement is very sustainable, so we just do not understand why there's any harm to the spatial strategy. This settlement is sustainable and has already been accepted, as I've said, by the council as suitable for major expansion, and the proposal will help to sustain it. The third reason is, of course, the age and status of the plan. The plan in December will have its 10-year anniversary. Both are more than 5 years old, which, Mum, you will know is an important threshold in government policy. The plan is only due to last for 2031. There have been Regulation 10A reviews, and the spatial strategy, we say, was devised in a fundamentally different policy context and housing market from that which pertains today. There's also a different requirement, as you'll hear this afternoon, on the basis of a housing requirement which is now superseded. The standard method figure for this district is different to that in LPD1. We've also got the length of the plan, reason 5. The strategic choices made in 2016 about the distribution of development cannot be expected to constrain necessary housing delivery in perpetuity. Reason 6 is, as you'll hear, about the 5-year land supply. And lastly, the effect of the NVPN. And we are asked you to consider the guidance in paragraph 11D. We are required to start admission unless adverse impacts significantly demonstrably outweigh the benefits. And we say the out-of-date status of the spatial strategy policies is not a matter which weighs against grant permission, rather it's a trigger the application of the tilted balance. So therefore we say the harm to the spatial strategy should be given limited weight, and we also ask you to deploy that in your balance as you'll hear in evidence. Secondly, we've got landscape character and visual amenity, but with no landscape reason to refuse. We say, for the reasons I previously said, no relevant designation. There are also clearly defined and defensible boundaries. We also say the site is visually well contained. The LVIA concluded that the landscape and visual effects, which are inevitable on a greenfield site, would not be greater than moderate significance. There would be no significant effects at a wider landscape character level. Therefore, the development has been designed to retain existing landscape features, including hedgerow and trees, and noteworthy, no allegation of harm to loss of trees. and there will be a comprehensive landscape strategy. Therefore, the limited landscape arm would arise as an inevitable consequence of developing any greenfield site, but it is localised, contained, and capable of mitigation, recognised by the council's own landscape officer, not amount to refusal, which should be given moderate weight. Agricultural land, again, not a reason of refusal. I think that there is about 3.3 hectares of grade 2, which equates to, I think it is from memory, 29%, the remainder being grade 3B. This is a factor weighing against the proposal, albeit it is which is common to the majority of greenfield. Again, Mr. Duval will say moderate. Then there's a harm to settlement from cumulative growth over time, which Ms. O'Neill seems to grapple with, not the reason of refusal. But our response in relation to there's no harm to the settlement because all matters are dealt with by section 106. The fact the council permits development to the east shows this is a settlement capable of accommodating significant growth. Site lies at the opposite end of the settlement. It will not result in coalescence or any unacceptable form of ribbon development. You note the council's own evidence base in 2024 considered that the site was appropriate for further consideration, confirming the council's own evidence base recognises the site's suitability for residential development. And again, you've got the allocation of 660 with the grant of outline permission. And it's very difficult, certainly from this side of the room, to understand how the council can support up to 668 in this settlement and say to you that 249 to the west should be considered inappropriate. So lastly, Ma'am, just to finish on the overall planning balance, of course, in your decision, you need to grapple with section 38.6. Our primary cases of the appeal proposal do not conflict with the development plan as a whole, because any conflict with the policies that are alleged by the LPA is limited in nature. The proposal accords with all the other 34 policies in the development plan that are relevant. Therefore, when read as a whole, including CP1, where there's no breach alleged, we overall take the view that the proposal complies. However, if our 11D is engaged, the question for you will be whether there is significantly demonstrable impacts that outweigh the benefits. We say they don't, and the benefits that I've set out. And for the reasons I've also dealt with on the balance, that we say limited, modest agricultural land, no harm from cumulative growth. Therefore, overall, in opening this case on behalf of the appellant, we say that the adverse impacts could not significantly demonstrably outweigh the very substantial benefits. And as you'll hear in our case, the appellant will ask you to grant consent after having heard the evidence. Those are the opening submissions of the appellant.
Thank you very much, Mr. White. Can I please just check that this has been sent electronically to the council for it to be uploaded to the council service?
Yes.
Thank you very much. In which case, Ms. Lambert, over to you, please. And the same question again about whether it can be transferred electronically to uploading. Thank you.
These are the opening submissions on behalf of the council. This inquiry follows the refusal of an outline planning application by Vale of White Horse District Council on the 20th of October 2025 for inter alia up to 249 dwellings, originally for 8 reasons. Since the application was determined and all the appeal was submitted, further information has been provided by the appellant and various matters have now been overcome. However, there are still issues outstanding between the parties for determination at this appeal. Following your main issues, whether the location is acceptable, whether the council can demonstrate a 5-year supply of housing, and whether on the flat planning balance or the tilted planning balance, planning permission should be granted. The council's case, firstly, the development plan. The NPPF sets out government policy in a concise framework. Paragraph 15 tells us that the planning system should be genuinely plan-led. and that up-to-date plans should provide a positive vision for the future of each area, a framework for meeting housing needs and addressing other economic, social and environmental priorities, and a platform for local people to shape their surroundings. The national context of up-to-date local plans is well known to be poor. This council benefits from a relatively recent development plan. Part 1 was adopted in December 2016 and therefore found sound post-NPPF. And Part 2 was adopted in October 2019. Part 1 was subject of a review in 2021. Part 2 was subject of a review in 2024. Together with South Oxfordshire District Council, Vale of Whitehorse has also made considerable progress with a joint local plan, which was submitted for examination on 9th of December 2024. NPPF policy provides that the delivery of sustainable development should be through the preparation and implementation of plans, and emphasises that development plans remain the starting point for decision making and in determining whether a proposal is in fact a sustainable one. Conflict with such up-to-date policy is, in NPPF terms, an adverse impact and should normally mean that permission is refused. In this case, the development plan was made in the context of the NPPF and had taken fully into account the objective of significantly boosting the supply of housing, including various factors that inform sustainable development. The clear spatial strategy sets out where developments can and cannot go. This is an unusual authority with an up-to-date local plan which has already submitted its new local plan, the preparation of which uses considerable resources, both in terms of finances and personnel, for examination. The spatial strategy has been successful, delivering thousands of homes, co-located with employment and infrastructure, and that strategy is taken forward in the JLP. The council has a comfortable 5-year housing land supply, demonstrating the success of its spatial strategy. Relatively and actually, the strategy is working in Vale. The council has also made considerable progress with a new joint local plan, for which examination is still ongoing. Whilst the inspectors examining the JLP made interim findings regarding the duty to cooperate, the council identified errors of law and notified the inspectors. Furthermore, and importantly, both the interim findings and the council's response predated the letter to the Chief Executive of the Planning Inspectorate regarding local plan examinations from Matthew Pennicott of 9th of October 2025 and the response from the Chief Executive of PINS. The council has written to the examination inspectors further to the Pennicott letter, noting his expectation that local plans submitted in the current plan making system should be treated with an appropriate degree of flexibility, specifically referring to the duty to cooperate, asking inspectors to be proportionate in what is expected as to the duty to cooperate evidence, and to consider the context, in stating that as a plan submitted under the current plan making system, his message is directly relevant to our joint local plan, and inviting the examination inspectors to reconsider your initial letter. The examination hearings have been reopened and a further inspector appointed. For the avoidance of doubt, the council has not withdrawn the JLP and it remains at examination. Through correspondence with the examination inspectors, the council has demonstrated that it is committed to the JLP. For the purposes of this inquiry, LPP1 and LPP2 are the relevant parts of the development plan, and it is the council's vision that it will be replaced in due course by the JLP and in further due course by JLP2. The harms and benefits. The proposals represent significant and unplanned development on an unallocated site at the edge of the village of Kingston Backwoods, a village which has already accommodated significant growth, including allocated growth. The development plan does not just identify sustainable settlements, it determines how much growth should occur, where growth should occur, and how it contributes to wider strategic objectives across the district. It matters not that there are no residual technical objections to the proposals. The absence of such objections does not overcome the substantial conflict with the spatial strategy, which lies at the heart of the development plan, and considering the council's 5-year housing land supply, planning permission should be refused. If the tilted balance is engaged, an assessment of the most important policies is still required, and weight to policies is a matter of planning judgment, taking into account, inter alia, the scale of the shortfall. This is not significant, even on the appellant's case of 4.24 years. The main benefits are mainstream housing, market and affordable. Current policy requires 35% of the housing development to be affordable homes. The evidence base of the JLP sets out the minimum affordable housing need of 3296 for the district, and the preferred option is for the minimum requirement to increase to 40% per veil. The proposals only provide the minimum affordable housing required by current policy. Those social benefits and the consequential economic benefits are not unique and will be delivered on sites for housing that will come forward over the planned period, as will any non-unique resulting economic benefits. To conclude, housing is acknowledged to be important. A housing in a location contrary to the strategy of a local plan does not justify departure, especially where the local planning authority has a 5-year housing line supply, strong completions, and a commitment to proactively producing new local plans with strategies shaped by local people. And Mark, in due course, you will be respectfully invited to dismiss the appeal. Thank you.
Thank you, Sandbert. So now everyone will understand the positions of the main parties more fully. We're going to allow an opportunity for the interested parties to make their representations to the inquiry. Councillor Rayner, can I ask for you to please turn on your camera?
Morning, Mum. My comments are very short and sweet. I've heard the council's opening statement and support the case it will be making to this inquiry. I am, however, disappointed that the council did not find any harm to the character and appearance of the area or the suitability of the location, as you will see expressed by the parish council's statement proposed by Mark Doods. I'm sure when you visit on your site visit tomorrow, you will see the actual location and how it cannot not affect on this side of it. And basically, I've looked at and read statements, and all I can say is that 100% I and know the residents are behind the council's statement, and just I can't say enough how much I support the council trying to stop this happening.
Thank you, Councillor Rayner. Those points are understood. I don't have any questions for you. I just need to check with Mr. Wright. Thank you very much.
Thank you.
Mr. Graham Thompson.
Thank you. Can you hear me okay?
Yes, loud and clear. Thank you.
Thank you. Good morning. My name is Graham Thompson, and I have been a resident of Spring Hill for the past 20 years. I'd like to speak today on behalf of our group of 30 local residents who formed a group called the Land North of Spring Hill Group, and we have been objecting to this proposal all the way through. My house is the lodge, which is in the middle of the planned site, surrounded by the planned site, just for context. I'd like to outline the reasons why we're objecting to the proposed development, and I will send in these comments afterwards. I have prepared a number of reasons why we think this is an unsuitable site. First of all, the site, as we've talked about, is an open countryside outside the settlement area of Kingston Bagbury and Southmore, as detailed in the draft neighbourhood development plan that's underway. There is no coalescence between the site and the settlement area of KBS, and this crucial gap must be maintained according to the local plan. This assessment has been backed up by the District Council's earlier pre-application advice on this site. I'll just turn off my phone, sorry. The pre-application advice on 30th of July 2021, which stated, should your client wish to pursue an application at this time, it would not be recommended for approval, as the proposal is in an unallocated site beyond the built-up area of the village, extending into open countryside, which does not accord with the district strategy for housing growth. Further to that, the proposed development would have a harmful impact upon the landscape and prevailing character of the area due to the proposed pattern of development, which appears to be incongruous with and detrimental to the spacious semi-rural character around the site. This assessment that the land is in open countryside outside of the settlement boundaries, reinforced by a recent planning refusal on appeal of the proposed development on the other side of the road at Spring Hill Farm. I can provide the references in my written statement. The planning inspector there said it is outside the built-up area of the settlement of KBS, and therefore in policy terms is in an area defined as open countryside. For these reasons, the site is not an appropriate location for housing with respect to the council's spatial policies and conflicts with policies CP3 and CP4 of the local plan. So I believe there's precedence for refusing development in this area that is already outside of the settlement boundary. Second point, the land is classified by the Vale as an area of high landscape value. It's used for agriculture and is clearly of economic value to the existing landowner and tenant farmer. Has been cultivated for many years. As stated previously, there's a proportion of high quality grade 2 agricultural land, thus affording protection under planning policies to protect productive agricultural land from development. Once this type of land is lost to residential development, it is never regained. Thirdly, the development as outlined will be completely unsympathetic to the neighbouring hamlet of Spring Hill, which is characterised by low density housing in substantial grounds. As such, the proposal will have a highly negative impact on the landscape, being a rural, unspoiled, agricultural, open landscape, which will be permanently lost. Fourthly, the cumulative effect of the development that has taken place in KBS over the last 14 years has not been taken into account in this application. Since 2012, there has been a 70% increase in population in KBS against a 14% increase in the Vale of Whitehorse overall in the same period. This growth has significantly impacted on the community with minimal infrastructure improvements over that same period. There's a severe shortage of educational provision within the area against the backdrop of cumulative expansion of the housing development that has already been approved. I can see no mention in the applicant's submission of any contribution towards the expansion of John Blandy School or Longworth Primary School. There's also a severe shortage of medical provision in the local area. Fifthly, the site is unacceptably affected by noise from the A420, and any development would contribute further to that traffic noise. No mitigation measures can satisfactorily address that issue, so building on the proposed site is contrary to planning policies. Six, the proposed new access road to the eastern side of the site is located close to a very dangerous bend in the road with limited visibility sprays. There's a long history of speeding vehicles on this stretch of road, and building a new entrance to a residential development will make travel in this area even more dangerous. A traffic speed survey was conducted on Speed Hill, commissioned by the Parish Council in response to concerns about excessive vehicle speeds within the village. This showed that approximately 55% of all vehicles travelling in both directions during the survey period exceeded the 30 miles per hour speed limit, with a significant portion exceeding it by more than 10%, more than 10 miles per hour. We even had someone doing 90 to 100 in the 30-mile speed limit. Turning to the very dangerous Charney Bassett Pinewood junction with the A420, which I'm very surprised has not been raised as a significant concern in the documentation around this application today. I've had a freedom of information request, and I've discovered that there have been 3 fatalities, 11 serious injuries and 26 minor casualties over the last 20 years. And the trend is increasing with the growth in population of KBS. It is the right-hand turning into and out of this staggered junction that poses the most danger. This stretch of road has a history of motorists speeding with some of the highest speeds ever recorded in the country. Building 249 extra homes in this area would greatly increase the level of traffic using that very dangerous junction, potentially leading to more serious accidents and deaths unless a roundabout is built. Number 8, I'd also like to flag the highly dangerous foot crossing of the A420, which you'll see when you come on your site visit from Spring Hill in the direction of Longworth. I know from personal experience how dangerous it is to cross this A420 at this point, with a lack of visibility towards the speeding traffic coming from the direction of Oxford. The risk to any children who may live on this site crossing to the Longworth School would be substantial. The only way to fully mitigate this risk would be to build a footbridge over this deadly stretch of road, as there is one further down into KBS. Number 9, the travel plan in the proposal includes provisions for improvements and additions to bus stops that are not deliverable. Because the proposed bus shelter outside my neighbour's house at Cedars overlaps private land, not highway land, and that is subject to a county court, Oxford County Court case reference, which I can have in my documentation issued in July 2022. Number 10, the site is crossed by 3 public footpaths, all of which will be unacceptably impacted by the proposal, reducing public enjoyment and physical health and being. Number 11, I'm getting close to the end now. Currently, the stretch of road on Spring Hill is used extensively by the riding school for the disabled, which is located very close to the proposed development. With the likely increase in road traffic in new road junctions, there would be increased dangers for these vulnerable riders. Finally, number 12, there are other issues that I believe would impact the sustainability and deliverability of this particular site. These include there is no comprehensive sewage system on Spring Hill. There is a problem with water supply and with flooding at the bottom of Spring Hill. The proposal includes no proposals to upgrade either the water supply or the sewerage, so there's insufficient infrastructure to allow the proposal to be deliverable. Currently, the pavements are largely inadequate width-wise around the site and often blocked by overgrown foliage. In conclusion, myself and our group of local residents believe that for all these reasons we have mentioned, the site is not suitable for development. There are other much more suitable sites that are available within the Vale of Whitehorse and within the local plan, and that this appeal should be refused. Thank you for allowing local residents' voices to be heard at this inquiry. Thank you.
Thank you, Mr. Johnston. Just a couple of questions from me, please. Firstly, thank you for confirming that you would send through your representations. Can I confirm with you that the appeal reference to which you made specific reference is actually within that written submission?
Yes, it is. It's P25//V1865//O. Appeal reference is 6003709.
Thank you. I'm going to ask the main parties to make sure that that's in the core documents list. That's okay. It's in there. Thank you. I thought it might be. I just needed to double check. Wonderful. So my other question was, can you explain to me the point about coalescence that you're making, please?
Well, basically, this is outside of the settlement boundary. Therefore, if you build houses on here, it will coalesce with KBS. It's also a long way from the local school for people to walk, so everyone will be driving their cars to the local school, further increasing the pressures on the village. So basically, we're saying this is open countryside. Any development here will be coalescing against the existing development into open countryside. So ribbon development, I believe, not being a planning expert, is not favoured in the spatial housing strategy. So that's my point, that we have to maintain this important gap of countryside.
Okay, thank you. Your point about the lack of contributions towards the school, have you seen any correspondence to the effect that the school requires them to provide the capacity needed for future residents?
I believe the school has had contributions from previous developments and now has probably reached its capacity for the current site in terms of developing its footprint. But the parish council would be able to confirm that more. Obviously, 249 houses will put significant pressure on local facilities, and I know John Blandy School has been under pressure for a long time with increasing class sizes. You know, pretty huge class sizes. But my kids have grown up now, so I haven't got any recent experience.
Thank you. And so one other question was the unsafe junction to which you referred. Is that the Brilford junction, or should I ask the main parties to confirm that?
That is the junction, the Charney Bassett Road and Pinewood Junction. It's a staggered junction to the west of the site. You go down from this site down to the mini roundabout, turn right, you'll be on to the A420. I've lived here for 20 years. There's been 2 cyclists killed and 1 motorist killed. Numerous accidents, not all causing injuries. It's seldom a month goes by without we seeing accidents on that road. I know there are some planned and approved traffic calming measures, reducing down to 1 lane and reducing the speed limit at this junction, but I don't think that will solve it. Increased traffic, turning right against speeding traffic will always have a problem unless you have a roundabout, and I believe that that is what's required to prevent further deaths and serious injuries.
Okay, noted. Thank you very much. I will take the comments on board. I just need to ask Mr. White if he has any questions.
I have no questions, but I do have Mr. Tucker's just shown me the roundabout. Would it be helpful to identify for you and one of the LPA witnesses we showed?
Yes, please, just so I know where it's looking.
This one through. Yeah.
Right, so the kill sites here, there's a roundabout just to the west of the site, and then north of that, this is here, just the site. And not the site, the junction that has been referred to as that staggered. Just we'll see it when we go to.
All right, thank you very much.
The reference to that appeal decision, it's actually an appendix to Miss O'Neill's brief, so it's CDE 11D appendix 2.
Okay, thank you, Mr. Thompson. Were there any other interested parties here with us or online that wish to make their representations known at the stage? No. Okay. So that brings us to the end of the formal closings and interested party points. Obviously, should any other interested parties wish to attend on other days, I will have to hear from them. None have indicated they wish to do so, but obviously I will make provision for that if that situation arises. So it will be an opportunity to have an adjournment for a break now before we resume for our housing land supply roundtable. Question to you all. Do you want to have a longer break now and incorporate sort of an early lunch and resume for housing and supply discussion, or just have a short break?
My vote would be let's crack on, because the prize of finishing today's business without a deadline. I learned from them had a chat, you all have to be honest, in the light of the agenda. I think 2 hours is probably accurate for the bad table. If we break now, say, for 45 tasks with a fair wind, we finish today's business by lunch. I mean, that prize is quite special. And then we rather than have a break now, but it's up to you.
I'm doing my lowest member on the heat issue in terms of the longer we sit, the hotter the room is going to be again.
Understood. Okay. I'm going to suggest an additional 5 minutes then. So if we could resume at 11:30, be helpful. Thank you. I'm taking a minute. So we have an agenda which has been prepared and which I'm grateful, thank you. And that outlines the 5 key points of discussion. Firstly, with introductions, is that of the people that represent this particular issue? Seems to be very
Would it be useful to do a document audit introduction, just to make sure that you've got tabs open for any documents that we might be going through?
Yes, that would be really helpful actually. So we're going to have to do this a bit slowly, if that's okay. Can you list them so I can write them down?
So I'll list what I've got and then I'll let Sue just add anything that she needs to add to the list. So the evidence we read myself in terms of our land supply proofs. The council's housing land supply statement, which is CDI2. We also have most reasons to rebuttal as well, actually, I should have said, because we're going to send a rebuttal for it. And then we may well need both part 1 and part 2 of the local plan, which are CDG1 and CDG2. We will need the 2024 NPPF. Yeah. If anyone's on the line, it's CDF1. I imagine we've got our own copies of that. Lichfield start to finish 3rd edition, which is CDI3. Then you've got 2 housing land supply statement of common ground, which is CDE5, and then the more recent addendum, which updates the position, which is E5A. Then the council's most recent annual monitoring report, which is CDI1. And I suspect we may need to go to a number of appeal decisions. So there's the Chichester appeal decision, which is CDI6. The Woolpit decision, which is CDI9. Priors Orchard, which is CDL10. Backers Lane, which is CDL11. And Burdham, which is CDL12. That's all I have on my list. This week might well have.
I think that was all of mine as well, but yeah, no, I think that's.
Okay, thank you. Just give me a moment to get all of those documents for me. Mr. Neal, I need your appendices open as well.
Oh, yes, you will. Yes. We're going to try not to take you to too much of it, but we will certainly at the very end of it.
Sorry, the first Chichester one you mentioned.
First Chichester one, CDI6. That's, I think, I've got the wrong one. I've not got the right one. Yes, it is CDI6. For some reason, the electronic tag is not what the appeal decision relates to, but the appeal decision is correct. So you should have co-joined appeals, land east of Claude Road and up to Wall Land, west of Drift Lane and Chidham. Appeal decision 29th of August 2023. But unhelpfully, the electronic file reference has landed Salt Green Road.
Oh, it's
Just because I've only just noticed that, but the tag across the top is not, doesn't tie up with the actual document. Sorry. Thank you. Sorry.
Okay, I've got all of those documents available now to navigate between printed versions of the statement of ground and the vending master saying. Lots of printed extracts, those documents that I thought would be useful to hand to hand. So I think I'm back ready. We've done the introductions, matters and agreements. Although obviously that can be taken as read, I think it would be helpful just if either one of you leads on saying this agreement, just to help me set it in my mind.
Absolutely. Okay. Statement of common ground, main statement of common ground sets out the areas of agreement. So critically, we're agreed on 5-year period. It's a question, so that's commences with the 1st of April 2025, and that's going to take place in March 2030.
It is, and I guess on the basis that there are no student questions, I just want to ask, out of interest, at what point in time would it be appropriate to take away a statement of 1st of April 2026?
Not a stupid question. So, effectively, as soon as the council is in a position to publish the necessary data to be able to undertake that assessment. So, the council's position would be normally in a credit on as soon as the end of the documents produced with the necessary collection of the data. So, in the absence of the data, anything that was discussed in relation to the 1st of April, I'm saying would need to be objection.
Okay, so the end of the calendar year.
I think this year it might be a little earlier than that, and just due to it's not going to be available.
Okay, that's fine. The only thing that I'm going to say is unrelated to the topic of discussion is, can you both please speak a little louder? I'm really sorry. I'm conscious that we've got to get voices through to microphones to hear at the other end in case there are. Thank you. Thank you. I'll let you carry on, Mr. Anstey.
Okay, so and do pick me up if I tail off, because I do have a tendency to, so sorry. So we're also in agreement on the buffer to be applied to the calculation, which is 5%, and that is based on the most recently published housing and test result. And the test result is set out in table 1, the statement on the ground. So leading to that, we are in agreement on the calculation of the housing requirement for the 5-year period. And that is based on the standard method calculation as applicable at base date. So you will have seen, certainly in my evidence, reference to a higher standard method calculation, which is the most recent, most up-to-date figure. It is not the figure that is being applied for the purposes of this 5-year supply calculation.
Can you just explain that again a minute? Sorry.
I can. So the standard method figure that is used, which is set out in table 3 in the statement of common ground, is the standard method figure as calculated on the base date, which is 1st of April 2025. I have, and we may well come on to it at the very end of the agenda, I have referenced the most recent standard method figure, which is calculated as at 21st of May of this year, which is slightly higher. I've referenced that for a different purpose under the ban of 5-year supply. That is, the most recent figure is not to be used because everything should be coordinated with the base.
Yeah, that's understandable. It just does a snapshot, so I can put it in my notes. What is the difference between the two figures?
So the figure as at the base date is 949. The figure at the 21st of May is 970. 970 exactly.
Okay, thank you. That's just useful contextual stuff.
The agreed position then in terms of 5-year requirements, including the buffer, is 4,982 dwellings, which is 996.45 rather inconveniently per annum. So that's the requirement. Then just coming on to the supply side. So we are in agreement on the tests that demonstrated deliverability, so the Annex 2 test on the framework. And that's the test to be applied to Category A sites and B sites. I can run through that now, or if it's appropriate, we deal with it perhaps when we get to the sites in dispute.
Yes, the latter.
Yeah. We're also in agreement with the paragraph 75 heading evidence test, which is a different test applicable to greenfield sites. Then sticking with supply, we're in agreement in terms of the sources of supply that council are relying on, which is set out in table 2 of the statement of common ground. And that comprises Category A sites, which I just pause there as the addendum to the statement of common ground confirms we are now agreed on the supply from those Category A sites. So that is no longer a matter of dispute between the parties.
Yep.
Then the second category is Category B sites, which is where we'll spend most of our time, I suspect, in the next hour. And then the final category is wind floor. So that's the agreed position. I think the only other point to note in terms of agreement, which doesn't relate specifically to the discussion of 5-year supply, but we are in agreement on the relevance of the emerging local plan. And that is to say that the emerging local plan is not relevant to the calculation of 5-year supply. That's a matter of agreement. And that paragraph 2.14, we've also have an agreed position in terms of the requirements that the emerging plan is using relative to the standard method calculation applicable at the time of statement of common ground is report. But as I say, not relevant to the 5-year supply, but relevant to other factors.
Understood.
Unless I've missed anything, I'm happy to be picked up on anything else that needs to be raised. And those are the key areas of agreement.
Okay then, so we can move on to the Category B sites in dispute on a site-by-site basis. So I'm happy. Mr. Reid, do you want to continue a lead on your view on sites to the western part of the box, and then I'll ask them to respond on the points that she sees.
Absolutely. So if I can just preface this whole section then on the point, which is the Annex 2 test. So for Category B sites, the burden rests with the planning authority and seeking to rely on deliverable supply. And that test is that clear evidence needs to be presented that homes will be delivered within a 5-year period or in business. So it is for those seeking to rely on the Category B sites that need to satisfy that test. Those such as myself that are challenging that Category B supply merely to demonstrate that the clear evidence test has not been. So that's an applicable principle throughout the this section. I may take this in stages just if it helps the discussion, but there's quite a bit I need to run through on this site. So feel free to stop me if that would be helpful to you. Just for your notes, my evidence on this site is set out in Paris 611. The council's evidence in its land supply position statement commences at page 35, again, just for your notes. That's at appendix 3 of the council's position statement. And then Ms. Reed's position is then set out in paragraph 6.4.17 through to 6.4.6. So if we just start with the background context, the site has outlined consent for 4,254 dwellings, which was granted in February 22. Since that, 4 reserve matters applications have been approved between November 22 and March 24 for a total of 850 dwellings. Those 850 dwellings are not relied on by the council under the origin at an earlier stage. More recently, though, 5 reserve matters applications were submitted in 2025. And the details for that are contained in my table 8, page 25 of my proof, if you need the reference for those. Of those reserved matters, only 357 dwellings have an implementable consent. Yet the council is relying on 882 dwellings for deliverable supply in the 5-year period. So, just doing the mathematics on that, and it is a fundamental point, but 525 dwellings of that 882 are category B and are not deliverable, and are not deliverable either at the base date or now. The key reasons for that, if I can run through those. So the first one is the council are reliant upon officer assessment of the progression of the reserve matters applications. That assessment looks purely at the planning process. There's no analysis provided in relation to the delivery of each phase. For example, actually the post-consent stage, so pre-commencement of work on the site, planning condition discharge, infrastructure delivery, and other critical matters such as the overall site-wide construction programme, and also commercial and market conditions. But if I just pause on that point, we will come back to this again in Windfall discussion, but the market conditions, the state of the current market here, in terms of the evidence that I'll run through in the Windfall session, is equally applicable to these sites that are coming forward through category B. So there's no evidence to justify the council's delivery expectation, bearing in mind there are only 2 developers identified, Taylor Wimpey. And perhaps quite importantly, the council's ignored the responses from Taylor Wimpey when they consulted them regarding particularly the delays that those developers have cited in the planning process and the necessary amendments that they needed to make to the scheme. And critically, they've totally ignored the delivery trajectories provided by the 2 developers. And they've gone with their own estimates. And I say this is critical because it's actually contrary and contradictory to the approach that council has taken on its other TBD sites, where it has taken the trajectories provided by the developers. Following on from that, you'll see in my evidence, and we don't necessarily need to turn it up, but for your references, appendix 4 and appendix 5, I've included fairly lengthy documents, which are the accounts, most recent accounts for both Taylor Wimpey and Persimmon. So Taylor Wimpey's appendix 4, Persimmon's appendix 5. The reason I've included those is to provide you with the detailed empirical evidence from those developers as to their delivery rates. Taylor Wimpey's accounts confirm delivery rate of 39 dwellings per annum per outlet. Persimmon confirmed 36.4 dwellings per annum per outlet. So that's one measure to consider the council's delivery rates by. The second measure is the Lichfields document. We can turn to it, but again, I'm trying to keep the document shuffling to a minimum. We may need to go to it, but table 4.2 on page 14 of that document provides you with Lichfield's empirical evidence and a mean delivery rate of 149 dwellings. And for sites of this size, namely 2,000 dwellings plus. And then finally, the council has actually undertaken its own analysis of delivery rates on sites 500 that Valley Park fits within, and it actually includes the earlier phases of Valley Park, and that confirms an average of 133 dwellings per annum. And that's page 114, appendix 4 of the position statement. Now, all of those rates are lower than the rates that Taylor Wimpey and Persimmon have set out, which are lower than the rates that the council have estimated. That's why those points are relevant. It's also important to note that Taylor Wimpey are currently selling phase 6T, which is the 225 dwellings subject to only outline consent at the moment. I'm aware of this because my client is a house builder and they've been provided with sales certificates. Site's been marketed by Savills. And why is this relevant? Well, it's relevant because there is a reserve matters application running, but that reserve matters application contains Taylor Wimpey house sites. And as we know, all house builders will deliver their own product because that's what differentiates them in the market. So therefore, any purchaser of that particular phase, which the council is seeking to rely on, will need to vary the terms of that reserve matters application in due course and substitute their own design details. They won't build Taylor Wimpey house sites, they won't be allowed to. And with respect to Ms. Reid, her proof doesn't answer any of those points. Any of the stuff just rehearsed. And I don't believe that the adjacent site analysis that the council is seeking to rely on is appropriate because it does look only at the limited number of sites. It also focuses on peak delivery only, and that peak delivery is in the past, which comes back to the market points that we'll rehearse a bit later on. Doesn't take account of current market conditions. Whereas the data from the developers themselves clearly does take account of market conditions because they are in the market, they're aware of the market conditions. So all of that leads to the fact that actually there isn't clear evidence or a demonstration of clear evidence for the 882 dwellings that the council are relying on to be delivered within the 5-year period. In fact, the evidence points only to 357, as I set out at the beginning. I have, however, taken the pragmatic approach with my figures, as you would see, and I have applied the Taylor Wimpey and Persimmon data consistent with the approach that the council has taken elsewhere to reach a figure of 600 dwellings. So my position, Madam, would be that the delivery from this site should be reduced by a number of 282 dwellings. And that would get you to, in my view, a deliverable supply from this site. But there is an argument that actually the 882 of its entirety should be reduced back further to 357. But my position is that was quite a lot. I decided to go all the way through it, so apologies if that was too much. I can always revisit it.
Understood. Okay, Ms. Reid, are you happy to provide your answer in response to that?
Thank you. Just, I believe you've narrowed down the dispute to the build-out rates, and I think that's what Mr. Lord was saying. But can I just go back on the applications? And so the 5 reserve months of applications that were listed in our groups, I think 3 of them were already given granted permission, A further one since we drafted the now commission. That's in 2025/V0879 which is referred to as phase 16. I believe that was launched commission relatively recently, June, the post the exchange of evidence. And I don't really need to be questioning whether that should be approving or not. It's more about the build out rates, but just to confirm the predictions last year when they prepared the housing and supply statement in terms of timings kind of all correct, and that pays the I am unaware of any marketing of that site. I've not been provided any information. I'm not in these evidence to support about this site being marketed sold. So I can't really comment on that, but all I think that only 16 months. Just to go back on the grade, because I think the article can build out rates here, so I won't go too much on the inclusion of that, but just on phase 3P, which is the one remaining notice application. As you'll see on there's an email from the case officer included in the proof of evidence in appendix 2. That Catherine Pierce, and she stated the re-consultation is taking place. She notes a short delay, which I won't read out here, due to an IT system. She says, I don't anticipate there being any major issues. There is now a focus on determining this application that will be likely to be approved in the next couple of months. Which would be mid-May, so that would be around mid-July. It's a slight delay of a few months in the timescale and having a supply statement, but given the quite quick lead-in times on these applications, I think the average is 7 months. Council have actually assumed 12 months, so that's going to be enough time. I won't dwell any more on that, but just to point out before I get into the build rates. So I think the principal issue between us is the build out rates, and that's the difference between the 600 and our 882. I think you're accepting the phases being included. The appellant adopts the developer's trajectory has been described as a generous approach, which adopts the 600 dwellings compared to council's 882. The council's position is that these figures are extensively adjusted based on price that we the developer's trajectory is clearly an important balancing point, and the council do have all advantage them. As you'll see as we go through the later principal lead, and if you have a look at any of the other sites, they're not the majority of the time. That is the approach the council take, even when they initially assume that higher delivery rates. They're often cautious. They're not actually determinative of what is realistically deliverable in the local setting. They're often cautious, and they reflect a commercial condition at that point in time. Whereas the council's role is to assess delivery on the ground based on the available evidence. Starting with the site itself, we've already been 117 dwellings delivered from the standing start in that site. This is stronger than the first year in Didcot, including Great Western Park and Didcot in the Didcot from the east, which demonstrates this site is capable of strong delivery and can deliver substantial numbers already. Looking at local evidence, Great Western Park, I would say it's directly comparable. It has an average of 287 dwellings per year. Multiple years, the dwelling at 350, 300 dwellings, doing that to build out rates there. So this evidence is set out in the council's housing and supply statement in appendix 4 and 4. So locally, in a similar strategic allocation, delivery rates are significantly higher than those used. Just turning briefly to the Taylor Wimpey evidence submitted by Mr. Name, the quotes a figure of 39 dwellings per annum. I had a quick look at that. I'm not too familiar with their accounts, but this seems to be derived from a sales to outlets figure, and it seems to me that figure is portfolio-wide and a national average across all sites, so including small sites, different markets. It's not site-specific evidence, and it takes no account of breakdown by site size or location or type. And when you look at Taylor Wimpey's trajectory of the site, it is unusually low for even the size of peak delivery of 96 dwellings per year, which is considerably below local evidence, even when the average is cited elsewhere in counted evidence. in the version of 114 to 119. More fundamentally, developers like Taylor Wimpey operate on a high volume delivery model. So once they're on site, they incur significant upfront and ongoing costs, and their business depends on maintaining delivery rates to recycle capital and manage risk. They deliver 10,000 homes per year nationally, and they're structured to deliver volume and supply. Same point applies to Finland. I think there was a figure of 36 dwellings per annum. Again, this is a national portfolio-wide per outlet, not site figure. As far as I can see, no breakdown by size, type, or geography. In terms of the wider market, the local evidence already demonstrates strong delivery in a portion of comparable sites. And overall, the council's trajectory is based on site performance, strong local evidence, and characteristics of markets. The appellant's approach to relies on national averages in some places and developer assumptions which aren't supported by the council's dynamic.
And you sum up, thank you. And further from you.
I think just 4 points, if I may, and I'll try and be quick. I'm not going to go over anything I've already said, so it might be 3 points actually. So if I just clarify the date, phase 6T, I've just had a look on the portal. The decision was issued on the 9th of June 2026. So what that means is that there's a reserve matters approval in place, which contains everything available within the table of gas types. So there will need to be a further planning process for future developer taking that phase forward. As distinct from the position that I set out in my evidence that, for example, a live reserve matters approval and purchase and potentially substitute gas types into that planning process.
So is it permission? Oh yes,
Reserve matters approval. Yeah. So that was the first point. Second point then, in terms of my reliance on the developers' accounts, yes, of course they are national.
Really big pain. I'm really sorry. Can we go back to this point then? But if Taylor Wimpey are, as you suggest, marketing the site, have you not then got to consider an alternative delivery rate from a different house builder to once they've sorted out the planning and commission, should they wish to do so?
So absolutely, I think that is exactly the point about the council not having clear evidence of delivery. If a future developer is coming on board to deliver that phase, we don't know what that delivery rate would be, we don't know what the lead-in time would be. But that's exactly the point.
I'm also a little concerned that obviously I'm including marketing.
I don't have the marketing documentation. My client was made me aware of the fact that they received marketing documentation and negotiated all the evidence that the site is on the market. That documentation could be provided to the country. I don't have it myself.
Well, can I ask you what Mr. Meaning see that?
I haven't seen it myself, but I trust my clients. Instructions on that.
Sorry,
that is largely speaking supplementary to my main case in any event. But the second point, I think, was a point on sales rates and my reliance on the accounts produced by basically developers. Yes, they are national developers, so that the accounts are across the whole portfolio. That's absolutely correct. And figures are based on sales rates, which is also correct. And usual, because a developer will not complete a market house or apartment until such time as it's been sold. There's very good reason for that, because as soon as the property is signed off as practically complete, it incurs council tax liability and insurance liability, and it effectively ceases to be part of the operation and construction site. So developers don't sign off practical completion of market properties until such time as they're being sold. It is usually a simultaneous transaction. A house sale completes, the property completion certificate is issued. So sales rates and completions on market properties are only the same. No, sorry, I realised there's a lot of walking in there.
Thank you for patience.
Right, no problem. And then I think the final point was again the suggestion that the council's evidence in Appendix 4 is more reliable. I did set out that point. So Appendix 4 confirms an average delivery build out rate of 133 dwellings per annum, which over 5 years would equate to 665 dwellings, so marginally above 600 that I suggested was deliverable in this instance. That's on what the house is.
660 dwellings.
665, so that's just simply 133 times 5. And those are all concerning.
Okay, do you want to move on to slide 2?
I'll just say two very brief things. Just to say about the marketing evidence again, if it does exist today, the council did not have this information when they were preparing this at their own state, and this literally makes a lot of not putting evidence beyond the base state to support position. And I think that would be quite a recent update. If it does exist, I think we have seen, and the council certainly haven't seen it when they were putting applications together. And that point, the council does have a solid proof man, John Taylor Linkage. And my question would be, why would they sign the framework before and continue to submit the versus applications if they were not using them to build outside? That would be information that comes from that at the time for the purpose. And just to quickly talk about the council average delivery rates, that is all sites over 500. There are quite a few in there that are close to the 500 rates, I think, off the top of my head. The figures I gave were a comparison with like Upton Park, which was actually with Amazon, so just to know that point.
I hear your questions about the actions and intents of house builders. I don't have any answers for you. I'm not sure that we're going to get those. So moving on to the next. So just in the interests of clarity, this has a land supply reference 1237. And this is next on plans and questions. Okay. Again, should we listening, if you could lead on this and then what else the council to
absolutely. So in the same way as with the first site, so the references are paragraph 625 to 637 by evidence. And then the appendix 3 of the position statement, page 21, is evidence. And this reads proof of evidence 6.4.3 to 6.4.16. So, again, background audit of the site. So, site benefits from an outline consent for 400 dwellings granted in April 2021. And between 2022 and 2026, 4 reserve matters applications were submitted. The council supply relates to 2 of those reserve matters, one for 108 dwellings, which was granted consent on the 15th of October 2025. And the reference for that one is E25/D1127/RM. And the other one, 129 dwellings, which is the final phase, I believe, of the development. And that is a reserve matters application that was submitted on the 26th of March 2026. So that's the factual background. Do you want reference for the 26 RMA, or it is in the
Yeah,
Yes. It's a matter of fact that at the base date, the 1st of April 2025, none of the supply relied upon was implementable or, in my view, deliverable. It's a matter of fact that now, as we sit in this room, only 108 dwellings benefit from an implementable consent of reserve matters approved. In addition to that, there are a number of deliverability problems for the site, and I'll just run through them. There are 7, but I'll just run through them in order. So you'll have seen in the evidence, both from myself and Ms. Reid, that the applicant sought to vary terms of Section 106 agreement, specifically on affordable housing. And that application was put before the council in 2025. And that was citing unforeseen cost expenditure. So effectively, the applicant was seeking to reduce the affordable housing contribution to the site. The council's land supply position statement confirms that viability issues needed to be explored. So that's the position of the council at the time the position statement was produced. The council refused to enter into a deed of variation for the Section 106 agreement, and you'll see the letter concerning that's in my appendix 7. Now, coming to the evidence on this, Ms. Reid implies that this matter is now effectively resolved on the basis that the final reserve matters application was submitted in March of this year, and that application contains a policy compliance level of affordable housing. That's paragraph 6.4.12. However, I think it's important to note the timeline. So the final reserve matters was submitted on the 26th of March 2026. Condition number 2 of the outline requires all reserve matters applications to be submitted before the expiration of 5 years from the date of the outline in the circumstances where the application is phased, and that is the case here. So 5 years from the date of the outline. And the outline consent was granted on the 8th of April 2031. So the expiry of the outline for the final phase was the 8th of April 2026, which was 6 working days after that reserve matters application was submitted. So I think it's quite evident from that the applicant has submitted the final reserve matters application just in time in order to preserve their consent, as indeed any sensible developer would do, but not, as Ms. Reid suggests, on the basis that the affordable housing and viability issue's gone away. So I think that's quite an important point to raise, because we cannot, neither myself or Ms. Reid can be certain that that viability issue is fully resolved and that there won't be a subsequent application from the applicant. But the timelines would tend to indicate that the reason for the submission of that reserve matters application was to protect planning permission. Notwithstanding all of that, my position is quite simple on this site. 108 dwellings have an implementable, it's going to be a difficult word throughout this, and deliverable consent. Not the total that the council are seeking to rely on, and therefore a deduction of 92 dwellings should be made on that basis. If you check, the council has not satisfied with their own test for that. Just for completeness and fairness, so the final phase reserve matters is for 129 dwellings, of which the council are relying on 92.
Okay, that's really good. Okay, yeah, I was just probably going to make similar points, just to want to confirm that the council have 200 dwellings in the 5-year period, and it isn't disputed the 108, it's the 93 remaining for the motion. And as it says, that was submitted on the 20th of May 2025. Oh, sorry, the previous one. This was the further reserve matters that were in March 2021 dwellings, of which we've got 92 in financing supply. In terms of the evidence that the council had at the time of preparing the housing land supply statement, they did have a signed report by the developer of the site, David Wilson Homes, and that's on pages 95 to 99 of the housing land statement number 25. At that time, the reserve matters hadn't been submitted, but the council concluded that given the history of the site and the submission of several reserve matters applications, it would anticipate to see the final reserve matters for 129 pages be submitted from the 25th to February election. But then were probably expected to be completed, and this is exactly what happened. As they anticipated, the reserve matters were submitted. Actually, before the end of the monitoring, the previous monitoring year 2025-26 were actually ahead of the schedule. The council anticipated this being decided within the year, resulting in the first completion in 2028-29, which is the fall. As mentioned, progress is actually ahead of schedule. The consultation period was due to end on the 2nd of July, and a decision to follow that. I do have an email update from the case officer in my evidence, and that's gone with my group. She confirmed that pre-application discussion took place before the submission of the application, and that she doesn't anticipate any significant issue with its determination. Given that a policy compliant level of affordable housing is now being provided on the base, take that it anticipates determination to mirror that of the basis. I note Mr. Lee's point about we can't guess the intentions of the developer, and I can't do that any more than he can. All I can look at is what the council have in front of them, and that's a signed performer. An estimate of when that reserve matters and was on schedule. We need to got the case of confirming that that application is.
Okay, so can I just quickly check on this point about the refusal of the deed of variation? How is that issue being resolved and run now?
I don't have all the issues with that, but given that the case of the has anticipated that it's no longer on issue due to the reserve matters now having a policy control. So she can confirm that is that's all reason. So the application is 39 affordable units, which has been confirmed to be policy provided by the housing delivery. This addresses the deliverability issue raised in the housing supply statement that the council refers to. This was submitted on the 4th of June 2025 and proposed to reduce the affordable housing from 20% to 2.75%, for units without being spent. And decisions declined to first made the council authorised to dedicate. However, it's no longer relevant given the policy compliant with affordable housing.
I mean, I think that just reaffirms the points that I made earlier that what we have in evidence of promises is a position where the developer submitted a request to amend the affordable housing and cited very clear viability issues. The reserve matters that's come in 6 days before the expiry. Includes policy compliant affordable housing provision, but there is no answer as to whether that is actually followed. And that's the point in terms of is it therefore deliverable? And the reason I say that is because, and you'll be familiar with the PPG refers to a number of examples of the type of evidence that can be relied upon to be supplied, and one of those is clear, relevant information about site viability, ownership constraints or infrastructure provision, so on. And we're talking here about site viability. We do not have clear, relevant information to confirm that even if this reserve matters approval is put in place, that it's actually viable. But actually taking one step back, the reserve matters approval isn't. So as a matter of fact, there isn't an implemented permission in place now anyway.
I'm sorry, did you say that there was a print format available for this? There is, yeah. Remind me of the core document reference on the page. It's in housing land supply statement, December 2025.
Don't think it was not, you mentioned page 95. I don't think it was 95. That's in my hard copy, that's really just doesn't agree.
Did you say not?
I've got just trying to marry up the site references. No.
Actually, I'm going to say, yeah. What's it to? I'm not happy.
So I've got notes on
Sorry.
starting at page, quite a few pages, starting at page 20, paginate page 21. So, yeah, paginate at page 21. I don't know whether it's the same in PDF, I'm not sure they were right.
Apologies, I had the January version of the page 21. So looking at page 24, so question 6 on the standard form, how many homes a year do you think the site will deliver? 50 in total per annum. Is that okay, if you quantify that, is that total council are expecting the site will deliver? In total, council have 46 in 27, 28, 92 in 28, 29, and but the actual numbers that the development gave are the same. It's still 200 across 5 years, but they started it slightly earlier. Because most any stage of thinking going that's actually quickly when we can't might be the takes some right the total match. Got some listening.
I cannot be on the this is more well this is about compliance with that other evidence test is another small discussion over the different freelancing. So I don't dispute there. The rates of 108 dwellings that rely on it's the principal points about there is a balance actually being capable of being relied upon because the council is not steps.
Just make one brief point. If the council have been concerned about the viability when they assess the potential reduction from 25 to 2%, then why would they do this? If the evidence is that there are liability concerns, I don't have that information, but it's just.
Close that out. That's exactly the point. We don't have the evidence. We don't have the evidence. So we don't know what the council's position is on viability. And that is fundamentally clear evidence test. The evidence burden the rest of the planning authority to demonstrate what is a reasonable prospect that that delivery will take place.
So we're going to move on to site reference on 1255 North of Abington.
But for ease, I think we can probably take 1255 and 1256 together because the graph is on the side. I mean, that might be straightforward because it's broadly similar evidence, I think, from both parties. So speed things up. So again, quick document audit. My evidence, paragraph 642 to 650. So 642 to 650 of my evidence, and then the council's appendix 3 commencing from page 73. And then Ms. Reed's proof of evidence 6.4.48 through to 6.4.6. Okay, so context, outline consent for 1,030 dwellings granted in October 2019. Council seeking to rely on 196 dwellings in a 5-year period for this site, which comprises 104 dwellings and 50 retirement homes, and then 42 dwellings, which is an equivalent arising from a 90-bed care home. So those are the two components of the site at 1255, 1256. So the position, as a matter of fact, at the base date, none of the 196 dwellings were delivered. As a matter of fact, now none of the above is actually implemented. There isn't an implementable consent in place. As a matter of fact, now there are no reserved matters applications submitted, unless the planning authority can update me as of this morning. For any of those three components over the two sites. So it is my position quite firmly that none of the supply, 196 dwellings, the council seek to rely on is delivery. Council's evidence is based on reliance from information provided by the planning consultant at the developer. That's page 75 of the screen. You see the details there. And this reconfirms per 6.4.51 that none of the indicative timetables provided by that planning consultant show a reserve matters being submitted before the end of the current monitoring year. So this confirms where we sit now in June 26, that there is not clear evidence of delivery. In addition to that, we know, again from Australia's evidence 6.4.49, that Bellway and David Wilson homes are involved on the site. So they're the two developers. Now, neither of those developers provide a care home product. There isn't any allowance in the council's figures for the fact that the care home product will need to be delivered by a separate developer, because neither of those developers produce care home products. So there is a sales process there to be factored into the equation. Now, this relates specifically to the 42 dwellings within the global North of 6. Nothing's provided by the planning consultant in the appendix to the land supply position statement to indicate that that process has even started or considered. But the overriding point that I come back to is the simple fact is clear evidence has not been demonstrated. That test has not been met, and this site should not be in 5 years supply from the April 25 postcode.
Quick one from me on this thing. So if you look at the agenda, and if you look at the two rows for sites 1255 and 1256, council's position is 100 for 1255 and 42 for 1256. That doesn't total the 196.
You're quite right.
About, I'm sure.
Very well spotted. That's probably, let me just double check. Unless Mystery can help you.
Would be 100 dwellings all well at 1255 and 42.
So it should be.
Okay, so 142 total. Yes. Which is what is reflected in the table.
They're 142 total.
Yes, the council pro forma has the 125 and 125 together. With a fixed fee. I don't think that was actually around.
So we're saying 142 total across those two sites. So I apologise for my 196. There is an error in my notes, but the council's category B 5 years supply has 42 dwellings equivalent arising from the 80-bed care home, 140 dwellings arising from the residential component, if I've read that correctly. I misread it. I have misread it. 142. Apologies. It is 142. I think that he's getting to me. I use that excuse. 142. Apologies. But, so my points remaining that it's 142, not 196. And I've got no apologies.
So 50 of those are retirement homes.
42. It's 50 retirement homes, 42 dwellings equivalent using the standard multiplier from the 80.
Are the retirement homes a product of either of the house builders on site?
One of them, yes.
What was the name?
think
Sorry, David Wilson and
the recollection. David retirement, yeah. I think it is David Wilson homes from recollection as well, where they do produce age restricted homes, but they don't provide a care home. Neither of the developers provide a care home.
the information in the report, who is that submitted by? By one of the developers or a combination of the both of them? Or, I believe it's the director of the planning.
Yeah, it's one. So
Both.
And usually the council sets out if a developer of the one partner site has responded in the rights that as far as that is going to, and we can't buy it over the weekend.
It's even kind of because
Yeah, and imagine if you go to box 7 on page 75, it actually says equally planning of the developers who are alongside the remaining development costs.
Okay then, so just to be clear, the estimation of reserve money submitted in 26, early 2027 hasn't gone out yet.
I thought it would be in that time frame to have, and that's time frame given by the agent from the performer. Not past that time frame. I don't really talk about it separate reserve months care and estimation without this April 2020 and whether it can be doing this message every year.
I don't think I need to go back over us to say this is really just now and nothing that's been said to you really changes that fundamental point of clear evidence. Test is not being met in this case.
I just would like to remind you that the test is actually a realistic test, and we've agreed to a definition of what that might be. In my view, a science former and as detailed information on timescales, and we are not out of those timescales constitutes me anyway. So I'm not really sure why. Just because they're not having doing yet, they weren't expected yet. That does not mean that we're
Shall we have a quick look at the agreed definition then of the requirement for evidence? So where do you want to take the submitted evidence?
Well, the starting point is going to be the Annex 2 test, which sets out the Mood to framework, and EPG provides useful additional advice on that. And there are a number of deals that are in the core documents, but I wouldn't suggest that we need to go to those. So I've got the primary paragraph in the PPG at paragraph 220 on page 11 of my proof. As I say, I would take as read the various appeals that I've referred you to, and you'll see that I've got an appendix that summarises those appeals and various subject headings. So I don't think we need to go there if you're content with that.
Anyone?
So we start with the framework. So the definition of deliverable has part A and part B, and we're dealing with part B, where the term of the previous is coming from. So where a site has outline planning permission for major development, so that's defined for residential tenant dwellings, has been allocated in a development plan as a grant of permission in principle or is identified on ground code register, it should only be considered deliverable where there is clear evidence that housing completions will begin on site within 5 years. So that's the policy test, if you like, within the framework. The reasonable prospect point is agreed it's a matter of common ground, but it is clear evidence that that reasonable prospect delivery that is required. Now the PPG then provides some guidance, so it's not complete, it's not an exhaustive list. So again, we're agreed on that the evidence test in terms of what documentation could be taken into account. This isn't closed list, but examples given of the current planning status, which we've rehearsed. Firm progress being made towards the submission of an application, for example, written agreement between the LPA and the site developers, which confirms the developer's delivery intentions, anticipated start of site build out rates. Firm progress with site assessment work, or clear relevant, and this is the point I actually rehearsed earlier, clear relevant information about site viability, ownership constraints or infrastructure provision, such as successful participation in bids for large-scale infrastructure funding or other similar projects. You had the reference in the PPG is in my footnotes, so I won't read that out, but that is just 1, 2, 3, 4 examples that it's made clear that those are examples. So it follows that some of those examples may be sufficient to meet this test. It also follows that more evidence may be required, depending on the site circumstances. My firm view, based on the cases that I've dealt with over a good number of years since this test was introduced, and based on what I have seen in terms of council evidence for this site, is that that test has not been met.
I think we're agreed on the definition of deliverable and what this evidence might include. We'll agree that it's not exhaustive, so we don't have to tick all of those options. My group is quite simple. They have a very detailed performance on this, from those details I've never seen when working for a council. It includes the current planning status, technical key comments, viability comments, ownership project. And most importantly, though, it has been sent to the developer with the agent up on up, because it has been signed, but it includes timetable when they sectors of it when to build that site. So in my mind, I'm not sure what my clear evidence is from. Just to remind them to be realistic prospects are feasible. I think it's a mentioned area, and that doesn't mean that it's guaranteed or it's guaranteed.
Moving on to the next slide. Okay. So that is obviously the one in the same village, site reference 1270.
That's correct, yeah. So if I go through in the same way, so you'll find my evidence Paris 659 660. You'll find the council supply evidence in appendix 3, page 78 onwards. This reads proof of evidence at 6.4.7 or 6.4 or 2, 6.4.69. So this site benefits from a hybrid consent with the residential and care home components in outline form, and that was granted in April 24.
Can I just ask then, for the interest of comprehensiveness, what is in the detail form that I didn't?
I know you're going to ask me that. If Miss Reed can help, if not, I will pull out the information within the position statement. I haven't got it in my notes, but you can bear with me.
So the outline consent for 660 dwellings being extra care development up to 72 units. 7, full consent for construction of 3 on roundabout to the A20 road, and 4 on roundabout to the A4 and Addington Road.
Sorry, can you just remind me again of the numbers of units that were granted and that type of thing?
660 dwellings. And extra care development 70 units, which is definitely applying the same. Yes.
Which I believe is the government's status. And for the avoidance of doubt, that's not challenged anywhere else in the position.
Okay, so when we use the term care home, we are referring to the 70 units, all right?
So the 70 units is then pro-rated back to 37.
Okay.
So it's a 70 bed care home that uses the government calculation, then it's pro-rated back to 37 dwellings equivalent. So they're not 37 dwellings, but it's allowed for in the site calculation. And so Reserve Matters application was submitted, I believe, on 6th of January this year for 605 dwellings, so not a full quantum of the outline. And there is also a deed of variation with the section 106 being progressed to change the housing provision and a section 73 to vary the terms of the hybrid consent as well. Both in progress. As a matter of fact, therefore, at the base date, none of the supply provided bonds implementable deliverable. And that remains the case now that the supply is not implementable or is not implementable consent base. Critically on this one, there are fundamental objections to that Reserve Matters application in terms of section 73, and they remain unresolved. And you'll see from my evidence, and I have included the relevant objections in my appendix 8, which is at the very end of my appendices. You'll see 2 objections from Sport England. Now, their objections relate to the approved requirement to provide provision as part of this scheme, and it's not included within the Reserve Matters application. In fact, the developer is seeking to vary the terms to remove it. Now, the Sport England objection is not simply we object to the fact that it's not being provided. They're actually very detailed objections, which we can turn up, but they are evidence objections of both the need for that provision, the reason why it should be provided, the relevant clubs that it would affect if it wasn't to be provided. So there's a very clear evidence trail there in terms of that objection. It is a significant objection to the sorting, and it's not resolved. What's also clear is the chronology here in the circumstances where the application is to proceed with the Matters application, and that is that the section 73 variation of the hybrid will need to be determined first, and it will need to go to committee, and Ms. Reed's appendix 3 confirms that, but this obviously confirms that position. I haven't seen it on an agenda, so I don't believe that it's been scheduled. I think the suggestion was that it would be at some point in the summer. But it's clear that resolving the cricket pitch issue, which of course is the subject of section 73, is actually fundamental to delivery on this site. Unless and until that section 73 is approved, the Reserve Matters cannot proceed. In addition to which, Ms. Reed also confirms, and that's 6.4.63, that there are a number of other outstanding objections. Now this is as at 16th of June. I haven't looked at the of net since the 16th of June this year, but nothing from the 16th of June that I can see has been submitted by the applicant to address those objections. So what you actually have, far from clear evidence of delivery, is you actually have evidence showing considerable uncertainty over the delivery of this site in its present form. Certainly not clear evidence required by Annex 2, and the site should simply be removed from 5-year supply.
Okay, thank you. So of the 605 dwellings that have been submitted as part of the Reserve Matters application, what are they? Are they all market and affordable units, or is there any of the care component on that?
Short answer is I don't know what the council is relying on from that. So the council is relying on 140 units, but as to how that's derived from the different dwelling types. I can't answer that, I'm afraid, but it's 140 units is the supply that the council is relying on this site and budget period. But all of those are tied up with this issue of section 73. Because they're all in a single reserve subdivision.
My think on this one probably links back to the point on the previous one, which was about the evidence that council had at the point of making this decision about whether this had a realistic prospect or not. And we had a signed for a clear one, once again by David Wilson Players, was on page 78 to 80, 82 of the Housing and Supply Statement of December 2025. That confirms the build-out rates, confirmed that their intention to submit the planning application. Obviously, just the detail. So there's a signed performer, and the council have aligned their delivery estimate to align with this performer, despite them being a little bit more cautious with the previous rates that they sent out in there. They send a table to the developers, and they adjust it if they feel they need to. They also indicated in this performer that they intended to submit a reserve matters application and the associated sections of which the application in November 2025. So that was the information that we had at that point. And developers did this, and they submitted it just slightly late in December 2025. So this was correct. There are matters to be addressed through the amended plans and sufficient further evidence ongoing. Yes, there's been an objection received from Sport England and the Council of Planning Infrastructure team regarding cricket pitch division. And this is the subject of the section 73 application, which seeks to amend the account. It should be emphasised that the matter does not relate to the reluctance by the developers to provide open space, more a question of the type of open space, as far as I understand it. And the time scale for determining the application is linked for determination of section 73. There's reference to legal that we've got an email from the case officer on this, and it's 3 years my truth. The case is actually up to at the moment. I think it was meant to go to in June, July. I'm going to have to get that. I'm not quite sure. That's the reason why there's no date. But so the council has assumed an estimate that typically takes 12 months for the submission of the matters determination to place the decision in December 2026. So we're still well within the period for decision, and we've still got a good 6 months in that period that the council allowed for making this decision. In my view, the site clearly had a realistic prospect at the time that they were considering this information on the site performer with rates that they intended to submit. They did, and it was build out rates 70 per year, which months to see. The issue with the cricket pitch and the ongoing application are for them potentially to consider it was the instance of its basic condition, which they're comparing now. And I don't really wait and manage in the which I'm suggesting to shortly.
So I think probably just one point, just to reiterate. So you're considering the evidence before you and by the base state is the actual position that you are presented with evidence from both sides. Effectively, more recently than that, this position was foreshadowed in the fact that the section 73 was identified as being necessary, and we cannot be clear here and now that realistic, I think the right word is realistic prospect. That's what I meant last time. Of delivery has been satisfied in terms of the evidence in front of me was actually 5 minutes.
So moving on to Rogers concrete site, reference 16366. Difference 85 running to the
Yeah, so, going quick audit that where you find the evidence, 9 paragraph 661, 671. Appendix 3 of the council supply statement, page 95 onwards. And Ms. Reed's proof of evidence 6.4, 17 through to 6.4.9. So, background position. Site benefits from outline consent of 95 dwellings granted in April 2022. And there was a reserve matters application submitted on the 3rd of April 2025 for all 95 dwellings. You'll note, or for your note, shall I say, that the grant of outline consent required the reserve matters to be submitted within 3 years as a standard condition. And that 3-year date expired on late April 2025. So the reserve matters were submitted very close to the expiry, 5 days, in fact, prior to the expiry. So its factual position at base date, the site wasn't deliverable. As a matter of fact, now the site doesn't actually have an implemented consent in place. There are objections outstanding to the reserve matters, including from the Highway Authority, which are currently unresolved. You'll see that from my paragraph 6.66. Now, if I just pause on this and just note that Ms. Reed refers in her 6.4.72 that the applicant actually resolved the Highway Authority's objection in September of 2025. However, you'll note there's actually a further response from the Highway Authority at the end of September 25 that confirms that there's still outstanding concerns and still have an objection. In addition to which, Ms. Reed helpfully confirms that there are further outstanding objections on a range of matters, and that's the 6.4.73. She also confirms at 6.4.75 that the promoter of the site, because this is controlled by the site promoter, not a developer, would be submitting further information to address those technical issues, but this hasn't happened. And if we stop at that point, there are further points I wish to make, but if we stop at that point, there isn't clear evidence of delivery from that. But beyond that, there is a Section 73 application pending on this site to change the bits. Ms. Reed's got an email, I believe, from case officer or one of the development management team, that's in her appendix 4, that confirms that Section 73 needs to go to committee and that it's likely to be in the summer, and that in common with the earlier site, it was to be determined before reserve matters approval. That's an inherently uncertain position. As I've said, City and Strategic is the site promoter. They don't build houses, they promote, so they do need to sell to a house builder. The council doesn't have any clear evidence presented in this inquiry that the house builder is in contract. There is a reliance on an email in Ms. Reed's appendix 4, as I've said, from the case officer stating that there is a development partner. But that's different to there being a contracted. House builders will need their own house types. There doesn't appear to have been any allowance for this considered by the council. And just by way of anecdotal background, which isn't in the evidence, but my client is aware that this site's been on and off the market for quite some time. That's just anecdotal, it's not really a fundamental point. And the reason for that is because, by definition, it's a concrete works, it's a difficult site to deliver, it's expensive. That element is in the evidence. The council's position is based on average delivery rates. But but it's also based on assertion that the outstanding objections can be resolved and that members will in fact approve the change to the housing mix. And also the assertion that the promoter's development partner will complete on the sale. Now, it is usual that a development partner will not complete on the sale until they have satisfactory permission. So it's very unlikely that the contract's in place. But in any event, there's no evidence of that contract, no evidence of timescale involved to get to that point. It's nowhere near certain. And that brings us to the concluding point that the clear evidence test has not been met in this case for this site and should be removed by the SI.
Thanks very much. Thank you. Just to remind you that the evidence doesn't require it to be processed and like a person in advising of the realistic concept. And I know I keep going back to the point that it's really important. Again, we go back to what information the council had at the base date, and the really base date compared to April. And I think a lot of these considerations are beyond the base dates. What the council has at the base date is defined performer in the promoter by showing them proactive discussions with officers regarding the provision of amended plan of document. Clearly shows commitment to the site. This is further highlighted by progress made on discharge and conditions. They maintain 25 baby discharge conditions. And on the 1st of April 2026, the site promoter submitted a version of the 3 application, the goods was already outlined. So I won't go into any detail, but it's altered the mix of dwellings to be provided on the site. And that's the case, the email confirmed in my evidence. The reason for that is that the developer from here, we are looking to amend the application for those requirements. So that shows that they have got development village. I think the email is appendix 4 of my evidence, and I think might be going to main to the fit, so his colleagues. It does fit section 73 is due to the applicant now the development department for looking to the sites again requirements. It also says that the section of building is due to be determined, but they due to the determination that sex is going to be which is going to be in this summer. So it's got me up. In my opinion, this site does have a realistic prospect and a silent principle by the site development the progress has happened since the council put it together that has been in line with what they said they would do. Once again, I'm not really sure how that's going to get to the crystal ball to anticipate how that application might progress. And I just also want to note that most actually anticipated first completions in 26-27, 5 dwellings that the council did take more building coverage and moved them back to the 27-28. The promoter indicated 30 dwellings per year compared to the council's average of 36, but the council decided to adopt the promoter figures. So even if the determination of application was to delay by up to 6 months to enable the determination of section 23, there is still, in my view, sufficient flexibility in the structure to ensure these conditions are still yeah, I think that's the achievement. Okay, thank you very much. Anything further from you, Mr. Mayor? Shall I go on to the next?
2 really small points. So, and I don't mean to labour this point about the realistic prospect point of the base state, but the council is giving evidence to you today, as I am. The council is also relying on material which postdates the base state to support this position as set out in base state. That's perfectly reasonable, as indeed is the approach that I'm taking. So I think we just need to have that clear in our minds for each of the sites. And also just a very small point back to Valley Park at the beginning. This is one of those examples where the council has accepted another rate presented by the developer, which was not basically well committed.
Okay, so moving on to site reference set 1735 Wantage.
Yeah, so again, just evidence audit. So my evidence paragraph 6.72 to 6.79. Council's supply statement appendix 3, page 66 onwards. Is reads proof 6.4.80 to 6.4.93. So, factual position, background, the site benefits are an outlined consent for 1,500 dwellings granted in July 2015, plus a further outline for an additional 34 dwellings. So this is a site where I am looking at delivery of the total, not delivery of the total figures. So this is not the principal site of the whole system of the Valley Park. So 10 reserve matters have been approved for a total of 1,213 dwellings. But the council seeking to rely upon delivery of 259 dwellings in the 5-year period, which at the base date did not have a reserve matters approval. So reserve matters approval application was submitted in July 2025 for 129 dwellings and approved on the 8th of December 2025. The remaining 271 dwellings against the outline, of which the council is relying on 130, so there's a lot of figures in here, still only has outline consent. So it's 130 dwellings for our purposes with outline consent. So as a matter of fact, at the base date, none of the supply relied upon by the council was implementable or deliverable. And as a matter of fact, now only 129 dwellings have an implementable consent. So that follows that 130 dwellings are relied upon by the council, which are, in my view, not deliverable. Reasons for this are that we see from the housing land supply position statements, which you will see in boxes 6 and 7 of the pro forma on pages 69 and 70, that St Modlin, who control the final phase, which is what we're talking about here, has not yet taken into the market and cannot therefore provide a timetable for the reserve matters. And this reads 6.4.90 confirms that this is understanding the position as well at the point at which evidence was produced. Furthermore, she confirms at 6.4.91 that the council has effectively assumed the likely timetable for the final phase in terms of the submission of the reserve matters and delivery of the dwellings. But from the evidence that we have before us today, there's nothing to demonstrate whether that marketing of the site that's not been referred to at its sale has been factored into that assumption. But in any event, the council have based its position on a generalised assumption and completely in the absence of any evidence from the developer. In fact, some of them have been deliberately vague because they can't provide a timetable for a site that they say they haven't got able to market yet. And again, anecdotally, not in the evidence, but anecdotally, my client is not aware that the site's gone to the market. They haven't seen it. They're a house builder in the market. One would expect that they would see it once it is taken to the market. But the fundamental point here is the developer is saying, I don't know when I'm going to deliver this site, but I need to sell it. And the council is relying on 130 dwellings based on developer saying, I don't know when I'm going to deliver it. It is not deliverable in that context, that it should be removed. And that is 130 dwellings removal. So the council rely on 259. So my figure is 129, removing 130.
That's my understanding. We're agreed on the visual section of the so I would just say Mr. Godwin did respond when they did something pro forma, so there is that evidence in place. That's one of the 66 on the next few pages, and then having my statement to 32. Yeah, so they did respond. So they have a time for forma. They didn't indicate a time scale for this, and just this is the last reserve site, but they don't say that they don't take forward. They don't give a date, but they did indicate delay on the site is forward. This is a very, very active site, and the council have then used evidence given that the development is specified in Monday, and the previous phase to anticipate when it's likely to state. So as shown on pages 66 to 67 of the Housing Land Supply Statement, since 2017, there been consistent practice, at least one, sometimes two, reserve matters applications submitted every year. Given this phase represents the final chance of the direction to suggest delay in submission of this one final application, in the past shows all response C pricing document. The council had assumed in their timescale it would arrive in early 2027, so it's still well within that time period. Typical determination rates for this district show this normally takes about 11 months for a reserve matter to consent. However, Crab Hill site has been much quicker than this, which highlights how much difficulty is agreed at the outline stage. It's on this site, it's consistently reduced to about 6 months. So the council have taken a cautious approach. They've assumed it would take 11 months, so a decision like late in 2027. The build out rates of 120 per year, but only 10 are assumed in year 4 to align with the decision in 2027. So despite the evidence that it's actually going to be built. In my view, this is a reasonably cautious estimate. There is clear evidence of quite as a realistic prospect going back to that term again. Delivery within 5 years. There is a planning performance in the developer. The site is very active, 1 to 2 reserve matter applications every year, and an average rate of 120 per year. The performer does note a slight drop in delivery, but says that this is expected to pick up, so it does indicate that they are intending to take that site forward. The council takes a cautious approach, therefore, and assumes that this reserve matter is coming only 2027, decision in late 2027. They've only actually assumed 10 dwellings will be completed on this part of the site by March 2029, which is quite a long way ahead. This gives from late 2027, when they're assuming quite a delayed decision to March 2029 to build 10 dwellings, which I think is probably quite a realistic approach. We probably likely something much faster than the reality. And then in year 5, 120 dwellings, which they've been running the site right. Just another point on this anecdotal evidence, we can't really rely on that. None of it's in it. So who have the earlier phases been delivered by? 130. The mix of history and story. Is there any understanding as to why some of them are selling the last things? When they say go out to market, it's not quite clear what they mean. I don't know if they mean go out to market when is there you're able to is there housing market ready for the to come forward? I'm checking. Mr. Lehman confirm this one.
Well, I think just to be very clear on this, the pro forma sets out position. Question was asked when will the next reserve matters application be submitted? That was the question asked for St Modron, and the answer was unknown as yet, as the phase has not gone to market. In addition, over the page, and this is the office's conclusion on the St Modron Homes, the master developer for the site, has advised that they still need to take the final phase to the market and that they are finalising the marketing for this currently. Furthermore, they are hoping that the lower build-out rate from last year will be back up. What we've got here is a lot of assumption and a lot of uncertainty, and This reads evidence to you is based on assumption and estimates. It's not based on clear evidence. In fact, the evidence that we have in the housing management condition statement from the developer is that this phase is unknown.
I think if this is an application for just one small site or medium site, where we have nothing happening already, the fact that this is the last phase of a very big site, I think council are reasonable looking at very local, very specific site-specific evidence on this site, including a reply from someone that they might be thinking of council quite detailed monthly estimates of when they might build. But I think it's clear that this site will come forward. I think the council have taken a reasonable approach in when that might happen. Like perhaps what they haven't said. And then just one other thing, my colleague pointed out that when they say go to market, they could be looking for market. Okay.
I don't think.
Okay, so the next agenda item is, unless you need to talk about the totals that have been slightly Southampton. The next agenda item then is the difference between you on the windfall allowance. So your position is that council shouldn't provide for major windfall allowance.
Should provide for a minor windfall allowance.
I think I said shouldn't. Sorry.
Oh, sure, sorry.
Should provide for
might have been shooting in my direction. So
my question on the major windfall allowance is this: if this scheme were to receive permission, your position is that 140 dwellings will be deliverable within the first 5 years. So
that's my client's position. Yes.
5 years. So that this one scheme alone will provide more than the council is even achieved. So
absolutely, if the council is here, then you just refuse. So it's that is in a position where council is saying you should not be constantly paying attention.
Okay, explain to me why you think it should not.
Okay, so well, would it be helpful? Just looking at the best way of dividing up between the large and small. I can do that, yeah. So okay, could we perhaps just start with the tests that we are required to consider? So just so that we are all on the same page, this is a matter of common ground. Paragraph 75 says that where an allowance is to be made for windfall sites as part of the anticipated supply, there should be compelling evidence that they will require a reliable source, or it is that again, they would provide a reliable source of supply. Any allowance should be realistic, having regard to the strategic housing land availability assessment, historic windfall delivery rates, and expected future trends. The second point relates to plan making primarily, but that is the test that we are considering, which is common ground between us. But I think it's important that we start from that. So the compelling evidence test is materially different to the clear evidence test as itself evident. And I think I just need to start by saying that the reference to expected future trends as part of that test, it is not optional. It is the case that the obligation rests with the council to meet this test. So if I come to major windfalls, I think, to be honest, there are a number of points which overlap. That's why I was just thinking the best way to present this. But if I'll go through the points that overlap for both, and then I'll just add in, I think, just the additional information to minor windfalls at the end, if that's okay. So we don't, for windfalls, have evidence for the breakdown of delivery in different consent types. For example, how much in the council's evidence is dependent on prior approvals or changes of use. That's the first really small point. But the critical point here, and this is the point that I'm going to need to spend a bit of time on, is we've got nothing from the council on future trend evidence. Nothing. The council's evidence is all backward facing. The council's rebuttal of my points, which I'll come on to, is also backward facing. So if you agree with me on that point, paragraph 75 test has not been met. Vidico no further. And that would actually be fatal to the windfall delivery full stop. But that's not the position I'm inviting you to take, and I will come on to that. So I think it is worthwhile just taking up the points that I rely on, which are at 6.92.2. It's my own evidence, right, which would be embarrassing if I haven't. Page 35. So I set out there, I think, 10 points. I'll try and skip through them without reading them because I know that you have read them, but I think it's important that you go through those points. We are in a period of extreme change in the planning system currently. There is current uncertainty given what was a relatively recent change in government, and then all of a sudden we now have a recent pending change in the Prime Minister. And that does have an impact on speculative applications coming forward, particularly for the SME developers, small to medium developers. We're also in a period where the UK economic climate is incredibly uncertain. We've got interest rates reaching their highest level in the last 15 years. And that's important because that actually goes beyond backward trend evidence the council rely on in terms of duration. And to quantify that, we've got the inflation hitting 10.7% of 22, which I've set out. Latest figures have come down, but they are still considerably higher than the position in 2021, which was for those people with the mortgage time glorious at less than 1%. As a consequence of that, of course, the Bank of England rates higher, which means borrowing's higher, which means those small to medium developers responsible for bringing the vast majority of these types of sites forward are struggling to raise funds and to service the debt. That also affects mortgages. It also affects the purchasing market as well as we know. So, and these are points. Perhaps I should have prefaced this. These are points which also apply to the consideration of the market in terms of various market-related comments I've made on this forward-looking trend. What is going to happen? The uncertainty. Now, there has been a marked improvement in inflation. That's fair. That has improved quite considerably, but we do still have ongoing uncertainty. We've still got changes to the planning system. We're told we're going to have a new framework in the summer. Whether we do or don't is a different matter. We've then got other government initiatives such as Help to Buy that doesn't exist now, and that's had a direct impact on the first-time buyers market. And then much more recently, we've had world events that have had a negative impact on the economy and the market. And I've made reference in my proof to the empirical evidence that supports that, and we don't need to go through that. So it's also the case that the development viability for the SMEs has become increasingly challenging. And you'll see that I reference a Home Builders Federation recent publication on that, dated from May of this year. That's in my appendix 6. And the headline there is that the Home Builders Federation determined the cost of building a single new home is now £76,000 on average, more expensive in 2020. Finally, political uncertainty, not necessarily at the national level, but we've had the 7th of May 26 elections, introduced more uncertainty at the local level. Now, that's quite a lot, and it's really reflective of why the government identified the need to consider future trends, and none of that has been considered by the council. None of this is presented in evidence, none of this is presented in the land supply position statement. Ms. Reid suggests that my deductions have been taken into account in terms of the evidence that I put in my deductions, in terms of what the council set out in their land supply position statement. That's not actually what Appendix 5 of the land supply position statement says. It refers to the changes in the council's land supply position statement, i.e. council's assertion that it has provided supply, and the emerging plan. It does not deal with these points I've just rehearsed with you now. In Ms. Reid's rebuttal, this is 4.1.7, she seeks to suggest that it's the need to present substantially local evidence of the relying on the national picture. Well, that's not actually the test. The test is for the council to present huge compelling evidence. But I've presented you 10 clear points that apply nationally. Now, the Vale of White Horse district's not operating in both. It's not independent of circumstances. It's not immune from these points. And Madam, you'll see that I've referred to a case in Chichester. And again, Ms. Reid suggested that the Chichester case is not appropriate. We should disregard that because the factors that case turned on were case specific. But she does also note that that case turned on the absence of sufficient evidence regarding future trends. Now, I just want to flag a few points in relation to that case because I think it is quite a helpful tool. It's not being put to you over and above the points that I've raised. It's just a helpful tool to it. Firstly, it was a case that I gave evidence in. It was also a case that Mr. White had the misfortune to be leading as the advocate. It's also a case that LSH, London Smith Hampton, acted as the council. It's a case that they advised the council on in the preparation of their land supply position statement as well, as distinct from the circumstances here. And furthermore, they actually produced what's termed as a critical friend analysis. So a third-party audit of the council's land supply, so independent of the appeal process, but purely for the purposes of their 5-year supply position statement, which actually has since been updated to March this year, I notice, that provided detailed evidence on infill trends in that case. So that case is directly comparable in terms of this particular point. And actually, I presented to you more future trend evidence than I had available to me at that point in time. And your colleague actually, and not only agreed with the position, but she went further and actually removed windfall allowance completely. So in that case, we were talking solely about major windfalls, which is why I come back to the fact that I'm not advising you to remove all windfalls, but we were talking solely about major windfalls, for which at the time I was making a deduction to remove them. She actually reached the view that it should be removed, which is the point that I'm making to you here. And that was despite having considerably more evidence from LSH in support of the windfalls than is the case here. Can I just deal with a couple of other appeal decisions because they relate to this point? So you've been directed in Mr. Ethan Futsal to 3 other appeal decisions. The reason why that particular case is not relevant and you should disregard it. Those are the full document references, CDL 10, 11 and 12. We don't need to turn them up, but it's relevant to note that council's position is that those cases, or at least 2 of those, are more recent than the case I referred to, and that they give a demonstration because those inspectors have a different view on being calls of the same authority that case in question was one isolated example. We've got a number of things. Firstly, all 3 of those cases are actually older, they're 2022 decisions, and they were all taken into account by the inspector in reaching her view on case I refer you to, which was determined on the 29th of August 2023. So I think secondly, therefore, I think that's actually a misleading reference. I don't think that helps you then in terms of those 3 cases. And if I just bring that all full circle, what all of that tells us is that the compelling evidence test has not been met by this authority. It is purely 100% backward-facing in its evidence base. It has not answered, despite having the opportunity and taken it to submit rebuttal evidence, it has not answered the trend. But notwithstanding that, I'm still taking the view that some small site minor windfalls should come forward, and that is what I'm inviting you to do. I have made a deduction or a reduction, should I say, to the minor windfalls, and that is in part in relation to the various points I've just raised, and also one additional point that I've foreshadowed, which relates solely to minor windfalls, which is that no evidence has been presented by the council to the extent to which completions are relied upon in greenfield sites on minor windfalls only. That was quite a lot. I apologise, but hopefully.
Okay, thank you. I've got a full picture, understood. Ms. Reid? I'm trying to keep this not too long for everyone's benefit. I don't want to go into your decisions. Just Italy notes that allocation involved. I will say that's a colleague of mine, and most of these things before my time, so I was not involved. And I can tell I don't have all the evidence behind that. I was just trying to make a point that there have been different decisions. Really, we don't have the methodology in front of us of how to work this out. And so I'd like to keep my comments so on how horse have approached this. Mr. Neal talked about the economic uncertainties and inflation, and I think the point that there's a very good one. Obviously, I'm not expecting them to apply to their own sites. And I'll leave that there for my colleagues in Poland potentially to pick up. Certainly, the case in Bonaparte North, I'm involved in a number of appeals, and they've got quite a lot of applications that we consider windfall. I don't think that there's a lack of market in this area. So just to summarise, the council's approach to windfall is in Appendix 5 of the handling and supply documents, and it's summarising the treatment postal funds in detail, but it is structured and it's an evidence-based assessment. It doesn't simply rely on past trends. The starting point of this assessment is historic delivery, and that actually shows that there's 574 windfall dwellings per year over the period. Importantly to know that this data set spans a long time period. It includes quite a lot of variable market conditions, to go all the way back to 2011, Brexit and various other things since, and it shows a consistent delivery, averaging 74. However, the council don't simply roll that forward. Instead, Appendix 5 sets out a clear and staged methodology. Firstly, the data is disaggregated and refined, removing greenfield and windfall and focusing on land-based wind only. Secondly, it filters it by type and land use, retaining only those categories that do show conditional delivery. And thirdly, it further refines by site size, removing larger number of sites over delivery have been less reliant. So through that process, the council removes the less certain elements of the historic delivery. What remains is a much smaller and more reliable component of supply. The final allowance is 180 dwellings per annum, and it only applies that in years 4 and 5. So giving a total figure of 360. And when you compare that to the average rate of 574 per year, you can see that 180 is quite a conservative figure.
The key point is this is not an optimistic figure. It's heavily filtered and conservative allowance derived from their own evidence base. It's only included in later years trajectory and it avoids any accounting of existing conditions and overrides deals. Again, that reflects its cautious approach. Mr. Dean says the council relied too heavily on historic trends. In my opinion, that's not correct. The historic delivery been the starting point. His point about economic uncertainty, it's generalised, it's not supported by any of the that is clearly very workable. And there's already a substantial reduction made. I could maybe understand the point a little bit more if we were, when it was but it's already a very substantial reduction applied. In the absence of any locally specific evidence showing delivering would go further, in my opinion, there's no sound basis to reduce the allowance from the burden of the fallen energies. Without repeating myself, it actually okay, understood. Okay. Mr. Newman, think about it.
So no, I think I've covered those points as well. Unless you've got any queries on the front.
No, I did. In which case, the last item on the agenda is tell a lie. Position of the parties, that's fairly well understood. So, position, the evidence of the body, and so that you need to
don't know whether this probably is the point to raise it. So, and I'll be corrected if I'm wrong, or don't have a wrong. But in council's own thing, this point made that the level of shortfall that I've identified isn't significant. Substantial. I can't remember the exact term of it.
So, with a 4.24 year supply of shortfall.
Not significant. I thought, yes, I thought I'd make a note of that. But just to address that, this is a point that council is frequently making. But fundamentally, policy test is, does the council have a 5-year supply of pots? But actually, more human, even a shortfall of one is significant, particularly if you are that one person that gets that or needs them. So I just don't find it a very attractive argument to suggest that the level of shortfall isn't significant in some way, or it supports the council's position. That's the only point I want to make there. Before we come on to the final agenda item.
Okay, so let's just be clear on it. The 4.24 million position is equates to a shortfall of sorry.
Equates to a shortfall of, I think there we go. Temporarily mislaid the addendum there. Right. It equates to a shortfall of 759 million. So that's table A1 in the
And then on the council's figures, the 5.34 year supply position results in having a surplus of 342 million.
Correct.
Total difference between is a combination of both of them.
It is. Do you like that?
Please, I know it's in there somewhere, but just anyway.
1,171.
Yeah, that's the one.
So the difference between positive 342 and negative 759.
Okay, so I'm happy to move on to the last agenda item if you're. Mr. Dean, do you want to take on this again?
I can do. Primarily the emerging local plan position. So there's only a couple of points on this, to be honest, and this is not it's not related to 5-year supply, but this is, in my view, some material to do with determination of this appeal. So, and as you'll see, it's set out in my evidence. So, Statement of common ground confirms the agreed position on the emerging local plan, as I've said from the outset. So it confirms that at the point the statement of common ground was completed, that the council was proposing in that emerging plan a requirement of 724.5 dwellings per annum, and about 76% of the equivalent local housing needs at the time. The council has since then updated its position, and that's for the purposes of addressing various points your colleagues have raised through the examination process. And as at the 6th of May this year, the council was asked to provide the updated local housing needs position against the framework 2023, which the plan is being examined against. And that has reduced to 694.5 dwellings. So that's the position that the council has put to your colleagues, which is 72% of the current up-to-date local housing need figure of 907. So that's as at May, 21st of May this year. So, and you'll recall 72% I think was mentioned by Mr. White. That's where that comes from. So what does that all mean? Well, it means that paragraph 236 of the current framework applies. And that is the case that the council will need to commence review. But also, what does it mean? Well, what it means is that the emerging plan necessarily is being produced against the 2023 framework, but it is not going to answer the housing need for this district as it stands now, the up-to-date position. And you'll see that I've quantified that in my paragraph 8.9, that the emerging local plan would fall short over the same 20-year period current local housing needs by 5,510 dwellings. By any measure, that's massive. And Mr. Reid quite rightly says, well, this isn't a determinative issue, but it is, however, a material consideration, and it's relevant to your assessment of, in my view, the assessment of the benefits of housing delivery from this scheme. The emerging local plan is not the answer to the current housing local. That was all I wanted to say on the emerging local plan. Madam, I do have a couple of notes on the points that Ms. Reid raised in her rebuttal about my evidence on the performance against the adopted local plan. If you're happy with what you've read, then I don't need to make those points really, because if you understood what I've put in my evidence, that's fine. Because I think Ms. Reid just raised a couple of points in her rebuttal about being unclear on the figures, but I'm happy to leave that as read unless it kindly come with you.
I'll probably ask you to just go through those quickly in a moment, but first,
It's a separate topic, yeah, absolutely.
It not being the full answer to the housing.
I don't actually have too much to say on this. I think, in my view, this is a direct relevant and agreed to the five-year housing and supply calculation. The national policy is very clear that five-year housing supply is assessed against the current NHN figure or the base rate, which is what we've been doing. And this is the basis agreed between the parties. The purpose of the immersion plan is different. It's part of the plan making process where housing administration is tested through examination, and it's not the mechanism for setting five-year housing and supply, it's decision-making purposes. I've set out in my evidence that the plan is being progressed under conditional arrangement, which is entitled to do. So I won't repeat all of that here. And any difference between the plan's requirement and the most recent local housing need figures reflect changes in national methodology during the plan's preparation. It doesn't actually indicate efficiency of planning every day. So the appellate suggested that the emerging plan may not deliver sufficient housing for the UK current needs. This is a matter for the local planning examination to consider. Understood. Okay, Mr. Reid, do you want to clarify before you go to the
So yeah, hopefully this will, but the intention of this is just to help you, madam, because Mr. picked up a couple of points which I'm grateful for. So it relates to the completion data, the analysis that I have set out in my section, section that comes. So section 3 of my so the council's housing delivery history, and Mr. Reed's quite rightly flagged, and I appreciate that the most recent monitoring year in my table 2, that there is data actually in the council's housing management supply statement for that monitoring year, which I had overlooked, and it's a slightly different figure to the one that I have. So that figure needs to be corrected. So in my table 2, we don't necessarily need to go through all the figures, but that figure needs to be corrected. But if it's the case that the housing management supply position statement is correct, then actually having audited all of my figures, some of the earlier figures need correcting. And what that actually means is the shortfall should be 383, and I have it 389. So it's a marginal difference to just accuracy.
My table 1, that's all going to be actually given over that.
That's brilliant, thank you. Then there was a query relating, this is just the second and last point, just the query relating to my figures in my paragraph 315, relating to projected supply. So just to clarify, I refer to projected supply here. So this is what the council said at the time the plan was adopted. It was going to deliver from all the supply sources to projected supply versus the actual delivery. And there are actually a couple of corrections here which I'm grateful because I slightly understood short. So I appreciate being picked up on this. So the council's delivery data, as I've set out in my 315, shows that 15,101 dwellings being completed as at 2025. There then needs to be a further 6 years of 1,211 dwellings per annum to be delivered. Now, I should therefore have said that that's a total of 22,367. There was a typo in my proof. And the shortfall I've identified is the difference between the supply the council was projecting in the adopted carbon pot 2 plan and what is required in order to meet that. And that shortfall is minus 2,992 dwellings, and I had it at minus 2,900. Yeah, marginal, but just important to correct that. So, in summary, and that what that section shows you, madam, is that shortfall against requirements minus 383, shortfall against projected plan supply minus 2,992. That was all I just wanted to clarify that.
Yeah, I don't have much to say on that point. I'm just doing on to table 4 of my Russell when it says in the information against the JLB requirements on the basis that is likely to be the requirement going forward, which shows that the projected completion is 19,644 by the end of that plan period, which seems to run in the requirement 14.
Thank you very much. Don't have any further questions, thank you. Right, our last legend is there, but James, leave that with me. So I hope everyone's still with us, nobody's melted, so that's...
Housing land supply has the tendency to see people melt away.
I know, right, we did it, well done guys. So for those of us going to the site visit, start and have a show of hands, it's going to be me. Sorry, Maddie, you're in there again. Thank you very much.
Tracy Smith.
Someone else?
I'll go Will Brown and Disking Homes and Simon Tucker from DTA, who's next door. This is our highways consultant.
Okay, great. So I'm meeting 4 of you. Has anyone got a suggestion as to what the meeting point should be?
There is in the middle of the site, there's a footpath that runs across the middle of the site, and if you pull in off Spring Hill, there is enough room for a couple of cars there. If you want to get your own part there, the rest of them park in the road.
Shall we meet there at 3 o'clock? So that's an hour and 10 minutes from now, which allows sufficient time for changes clothes or footwear or packing up lunch break. Is that okay? Wonderful. Thank you. So we're going to be adjourning until then. For those of us that won't be on the site visit, we'll be adjourned and we'll be resuming here again at 10 tomorrow.